Lord, with your lordship's indulgence, I'd
Yes.
like to mention item 14 and 15.
Yes.
Lord, I have personal difficulties in regard to these two matters. Because, my lord, there is a special division bench has been constituted today. I am engaged there and it will take whole day. Therefore, my lord, if your lordship's accommodate for this week only, I have taken the consent of other side.
On the request of Mr. F. Dr. Lawrence, Senior Counsel, appearing for the respondents in both these cases, made with the consent of the other side, hearing of these matters stand adjourned for a week, list accordingly.
Well, can your lordship fix it?
Yes, choose a date, 3rd week of March. Before that, final fixing date is difficult.
No.
You want it? It can come earlier also.
Better not to fix.
Yes,
Let it
that
be.
way it will come earlier.
Much obliged.
May I please your lordship? I beg to mention item 20 of the daily calls list.
Hmm.
My senior is out of station. His name is also reflected in his leave note
Hmm.
is also reflected in the calls list.
Yeah, you want adjournment
Adjournment for the
on the prayer of learned counsel for the petitioner,
no petitioner, respondent.
respondent made with the consent of the other side. Hearing of this matter stands adjourned for 2 weeks, list accordingly. Yes.
Applied.
Your lordship, this is for listing of cases, lead petition related to seniority matter.
Hmm.
This has come last time in the court on 19/10/22.
Hmm.
It is already 3 months. And whatever these respondents notices were to be served, these are all served. I inquired with the pending section. Notices, few people have responded also to that notice. So I want, I will request you for listing.
Seniority, what is the urgency?
Because there will be.
Tell me one category of case over which seniority dispute has urgency.
Sir, this is in connection with Food Corporation of India, where the seniority is, this year, they are all eligible for.
When do you want it?
I want day after tomorrow. If you can.
After 2 weeks, put a date, after 2 weeks. Yes.
Your lordship, I beg for listing a matter for order.
Hmm.
It's
What
a-
order you want?
I don't have the brief. On the last order, it was stated that, on the last date, it was stated that the order was supposed to come out after 6 weeks. That is on
That's
September.
correct, but if it is listed, what is the order you want from the court?
My senior haven't briefed me yet. I just,
Seniors don't brief juniors. It is the other way around.
yeah, I just got the information.
Then you ask him, you are mentioning a matter for listing, for passing some order.
Yeah.
Is it not necessary for you to tell the court that this is the order I am seeking in that matter? Otherwise, why should we give you a priority listing? Rings a bell, find out and come back. Come back.
May I please, your lordship?
Hmm.
Lordship, I beg to mention listing of an item from Eastern Lordship. It was last listed on 9/1/23, Lordship. We were supposed to serve a copy upon the municipal board, and it was kept in motion so that it could be disposed of soon, Lordship. Tomorrow, Lordship.
Give the number to, she'll find out why it has not been listed after that.
Lordship.
Give the case number to her.
Another prayer for listing, Lordship,
Hmm.
for order stay vacation, Lordship.
Next week. Next week.
28th, Lordship.
Yes.
Obliged, Lordship.
Meteor.
Yes.
But 439, and this man is my of neither his Kazi nor Sub Kazi, anything, madam. He has no relation with that guy, madam.
Hmm.
And he was taken to custody, madam, from the day FIR was lodged to madam, page 11, you was about page 11.
Who is the petitioner? What is his role?
His minor actually, in fact, here in forwarding report, page 12, you also find. His name minor is written within the sub Kaji. Your bottom, you also will find. After his name minors. Actually, he is neither Kaji nor sub Kaji minor. He is the Maulana, he is minor teaching in a private institution minor. There. Nothing, no minor, nothing at all. Moreover, this girl belongs to another village also. He does not know even the minor. Only
No, this child marriage, which is the law? What is the law involved here? Which under
Yes.
which law is it offense?
Prohibition of child marriage act, my lord, 9, 10 in the event of state. Yeah.
Is it a cognizable offense?
Cognizable non-bailable 2 years punishment, my lord. But here POCSO has been added.
Cognizable non-bailable.
Yes.
Which section?
2 years, my lord, your lawful fine. 9 your lawful fine. 9 punishment, whoever being a male child about so and so, extend to 2 years, my lord.
No, but the allegation against petitioner has he married?
No.
Then section 9 relates to the person who marries a child.
Married.
Then why have you arrested him?
Only after 10, my lord, maybe because they whoever false conducts, directs or abates any child. Yeah.
Which is the section? Which is the relevant section?
In fact, if anybody other than child, my lord, other than that, it may be section 10. 10 or 11 it may come. Other than those concerned. 11 was. 11 is punishment for promoting, permitting, solemnization.
11, section 11.
So nothing is there against him, Mario was kindness. Yeah, what they have written in the FIR, sorry, forwarding report, what red-handed matter, what does it mean? He was FIR was second. On third night, he was taken from his home, dead of night, from his home, he was taken. But then he was kept the whole night, then on fourth, he was forwarded matter. In the forwarding report stated, what red-handed matter. Purely matter without applying simple because of that's matter this crackdown started matter. The people, unless, and moreover, the child as well as family members not been even arrested till to the right. And marriage also, my lord, as per section 2, my lord, also, my lord, marriage can be declared to be void only by a court. And otherwise is voidable, my lord. Anyway, but I am not on that matter. My role, my nothing is there. That is what I am saying. For 10 days, my lord.
Mr. Das, trial is another matter. If charge is framed, but what do you want to get by custodial interrogation of these people? What is that? Either he has abated or he has not. Either it's a case of child marriage or it is not. For that, is it necessary to have custodial interrogation? What is the idea behind that?
Right now, it is difficult to say. I do not know what is there in the case diary. But from the ground of evidence, it says the accused person caught red-handed. I do not know what kind of red-handed.
Marriage is not taken.
Maybe he was performing the marriage.
No.
At that time itself, he was arrested. That I do not know.
2021, my marriage year lawful fine page 11. During the year 2021, marriage took place as per FIR. How court red-handed?
Yes, what do you have to say? We'll release him on bail. No CD. These are not matters of CD. Yes, heard Mr. Yes. Heard Mr. H.R. Chaudhary, learned senior counsel, assisted by Mr. Ayman, learned counsel appearing for the applicant. Also heard Mr. D. Das, learned APP Assam, appearing for the state. First up, the applicant herein was arrested on, what is the date of arrest? 4/2/2023. In connection with Abhayapuri PS case number 39/2023, registered under sections 9, 10, 11 of the Prohibition of Child Marriage Act 2006, read with section 6/17 of the POCSO Act, 2012. And since then he is in custody. By filing this application under section 439 of the CRPC, the applicant is praying for an order of his release on bail, full stop, by referring to the FIR, Mr. Chaudhary, FIR dated 4/2/2023,
Two,
2/2023. Mr. Chaudhary, learned senior counsel for the applicant submits that as per the FIR, the marriage took place in the year 2021. And it has been mentioned that the applicant was caught red-handed. However, none of the family members of the alleged victim girl has been arrested, nor any case is pending against them. Despite this, the applicant, who is merely a what is it, Maulana?
He is Maulana in a madrasa.
Maulana in a madrasa, and having nothing to do with
Neither
regard
Qazi
to
nor sub-Qazi.
Maulana in a madrasa and not a Qazi or a sub-Qazi has been arrested on a completely baseless allegation. Full stop. Mr. Das submits that Das submits that he may be granted some time to produce the CD and has objected to the bail prayer made in this application. Full stop. After going through the materials and record, it appears that the basic allegation brought against the applicant is one under Section 11 of the Act of 2006. First up, under the said provision, any person, including the parents or guardian of a minor, who is found to have promote or permit or negligently fails to prevent child marriage from being conducted would be liable to be punished for a maximum period of 2 years and also to pay fine, which may extend up to 1 lakh. Full stop. There is nothing in the Ejahar which implicates the applicant directly. Full stop. If it is a fact that the victim got married, if it is a fact that the marriage took place with a 17-year-old girl on a date disclosed in the Ejahar, then the persons responsible for the same may be punishable under the provisions of the Act of 2006. First of, however, for that, no custodial detention would be necessary, since the facts about the marriage are not only in the public domain, but also apparently known to the informant as well. Full stop. Under the circumstances, I do not deem it to be a fit case to grant more time to the state to produce the CD. Full stop. This bail application is therefore allowed. The applicant is allowed to go on bail by furnishing a bond of ₹30,000 and one surety of like amount to the satisfaction of
a special judge, not Salmara, or
special judge, not Salmala, Obhayapuri. It is, however, made clear that the applicant shall not leave the jurisdiction of the special judge, not Salmala, Obhayapuri, without his prior permission, and shall render full cooperation with the investigation in this case as and when called for. First, a violation of the above condition may lead to cancellation of the bail. BS stands disposal.
obliging.
Item 2.
May it please your lordship. Lordship, it's a 438 application. Prohibition of Child Marriage Act, my lord. My lord, FIR is at page 11.
Who are the applicants?
Applicant, my lord, petitioner number 1 is the alleged groom. Petitioner number 2 is his father. Petitioner number 3 is the mother of the alleged victim. And petitioner number 4 is the brother. However, my lord, in this case, no marriage was solemnized. Marriage was not solemnized. And in the FIR, it has been written that this victim was recovered from the house of the petitioner number one, my lord, that is also not factually correct. The police claim that
উপর একটা line লিখো তো, it has to be established that the marriage did take place and that too with a minor. Yes.
so, my lord, in this case, my lord, two things, my lord, the marriage was also not solemnized, and this part is also
And
not
that too with
factually
a
correct.
minor, and the applicant had a direct role to play in the matter. A line to add. Yes.
So, my lord, this recovery of the victim from the house of the petitioner number one, my lord, that is also not factually correct. So, my lord, we're disputing this, the entire marriage.
Yes, you appear and record your statement. We'll give them anticipatory bail here. Heard, Mr.
S. Nawaz.
Huh?
S. Nawaz, my lord.
S. Nawaz, learned counsel for the applicants. Also heard Mr. D. Das, learned APP Assam appearing for this case. Apprehending arrest in connection with Abhayapuri PS case number 22/2023, registered under sections 9/10 of the Prohibition of Child Marriage Act 2006. The four applicants have approached this court by filing this application under section 438 of the CRPC, seeking anticipatory bail. I have taken the FIR as well as the materials available in record. Call for the case diary fixing 13/3/2023. Heard on the prayer of interim bail. Having regard to the facts and circumstances of the case, it is hereby provided that in the event of arrest, the applicants, namely so-and-so, 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 shall be allowed to go on bail on furnishing a bond of rupees 20,000 and one surety each of like amount to the satisfaction of the arresting authority, subject to the further condition that all the four petitioners shall appear before the IO within 2 weeks from today for recording their statement. Let the matter be listed again on 13/3/2023.
Deeply obliged, my lord.
Yes.
Item 3.
May I please, my lord? My lord, the informant Rohima Khatun, who lost an affair, my lord, affair in case 13, my lord, whereby she stated that her 16-year-old girl was.
All right, same order will be passed. Your name, please.
Yeah, my lord, one thing I want to bring to notice your lordships. My lord, page 20, my lord. 116 statement has been annexed here, my lord. So here, my lord, some
Page.
page 20 of the petition. Yes, my lord.
Yes.
This is in vernacular, of course, my lord. Or the English translated copy, page 18, my lord. Page 18. my lord.
Whose 161 statement is this?
This is victim, my lord. A higher allegation barely against the accused number 1, my lord. I am not the accused number 1, my lord. I am the other.
Sorry? No, listen. This court is not concerned if there is marriage taking place in violation of statutory provision. Law will take its own course. That we have not, we have nothing to say. But the punishment is 2 years, and these are matters which have been happening since time. So we will only consider whether immediate custodial detention is required or not. That's the only point here, nothing more. We are not concerned with other things. Rest we'll see as and when the right time comes. At the moment, this court is of the opinion that these are not matters for custodial interrogation. We'll ask them to appear and record their statement. After that, you tell us.
Serious allegations are made.
No, you tell us, produce the case diary. If you see that there is something, this is not a NDPS case or a smuggling case or a stolen property case.
POXO is there.
POXO, you can add anything. POXO. What is the POXO here?
POXO added in the year of 2022, my lord.
Merely because POXO is added, does it mean the judges will not see what is there?
Yes, this is page 22. Baharule Motkai Mokoi Moklohi ବ୍ୟବসায় কৰিব prostitution. Then আৰু বাহাৰুলৰ দেউতা মদখাই মোৰ লগত বেয়া কাম কৰিব খোজে বেয়া কাম কৰিব খোজে these things are there. I leave to your lordship, but I have brought to your lordship. This is only arrive at a judge decision.
You will write in bold letters. Mr. Das is very strongly objected.
No, that is not the purpose.
Objected and objected and objected.
That is not the purpose, my lord.
No, that's all right. You are entitled to
According to
do
me,
it.
no, these are serious allegations. That is why I submitted that.
No, see, these are serious allegations. We are not acquitting anyone here.
I understand.
Nobody is preventing you from investigating.
I leave to question.
But Mr.
Yeah.
whatever his name is, K.M. Hassan, and counsel for the, so also for the case number 2 will Morigaon PS case so and so, same date, 13th March. Rest of the things will be same.
Item 4.
This is a 438 application, my lord. There also child
Same
marriage.
child marriage.
Yes, my lord.
All child marriage
The
here.
father, my lord. Father of the boy.
What is this? All child marriage case?
Child marriage clubbed with POCSO below.
Father of the boy, my lord. Petitioner is the father of the boy, my lord.
Mr. Bora, Angshuman Bora. What is this? What do you have to say on this?
Lordship is absolutely right, madam. They are not the dreaded criminals. And at this stage, they can file the charge sheet and subsequently when the matters will come up to the court, the matter will be decided as per the law.
These are not matters for
Matters of
custodial
the
interrogation.
interrogation is necessary. And this is prevailing from since then, and the 2 years punishment or fine. Both are, and the court will decide what will be the maximum punishment prescribed.
You proceed as per law. That we have nothing to say. If you find somebody is guilty, file a charge sheet, let him or her face trial, and if they are convicted, they are convicted.
Yes.
Why you want to? This is causing a havoc in the private life of people. There are children, there are family members,
Yes.
there are old people. This may not be a good idea to go for. Obviously, it is a bad idea.
Yes.
But then we will give our views when the right time comes. At the moment, the only issue is whether they should be all arrested and put in the jail. You don't have space in the jail. Come up with some bigger jails, then we'll see.
The message is otherwise also can be given, madam. The message that always can be given by way of filing the charge sheet and the sensitizing the people, not by arresting everyone.
Yes, your name, please. Yes,
J.
thank you,
Ali.
Mr. Bora. Yes,
J. Ali.
J. Ali. And what is the case number?
My lord, Joklavanda PS case number 15.
Chaklavada PS case number so and so registered under Y 376. Is there any allegation of rape here? Where is the FIR?
FIR case 10, my lord.
These are all weird allegations. Absolutely weird.
Marriage took place in the year of 2018. And they have 2 years, 4 months child, my lord.
15th March, same order.
I'm obliged.
Item 5.
Lordship. My lord, after is that says, my lord, 9 lordship. My lord, sir, my lord, child marriage act, lordship, the.
Child Marriage Act. Yes, 15th week.
Like that. Same order.
Supplementary list item 21.
Obliged. These are similar matters, we are also to deal these matters.
We'll issue notice and club it with the other matters.
Other matters are fixed on 16th of March.
All right. Third, Mr. H. Betala, learned counsel for the petitioner. Here is the amendments made in the petition. It is brought to the notice of this court that similar matters raising the same issue is pending before this court for adjudication and fixed on 16/3/2023. In view of the above issue notice of motion returnable on 16/3/2023. Since Mr. J.K. Parajali, learned counsel assisting Mr. D. Mojumdar, learned additional advocate general Assam, has appeared and accepted notice on behalf of respond numbers
1 to 4.
1 to 4. No formal notice is required to be sent to the said respondent. Extra copies of the writ petition be furnished to the learned government advocate Assam within 3 days from today, so as to enable him to obtain instruction and file affidavit. Petitioner to take steps for service of notice upon respondent numbers
5 to 23, Lord.
23. By registered post with AD within 3 days from today. Let this matter be listed along with WPC number
363 of 2020.
363 of 2023 and other connected matters.
Any promotion we made subject to that observation, any promotion made to the next.
Promotion, if any, made during the pendency of the writ petition shall be subject to the outcome of the writ petition. Therefore, whom
Respondent number 3, my lord. I am editing WPC.
then the
Yes.
regional name they give.
Right.
Yes.
There's a small.
Respondent number 3 garnered Mr. R. Bhar.
There's a small typography that I may be allowed. Milord.
What
That is in the, Milord, in the prayer, it's also have been 5 to 23. It has been written as 5 to 2, Milord. The word 3 has been mentioned in the prayer portion.
You have to give some penalty for that.
I'm-
You make a mistake and don't want to pay penalty. Why? Now, is it fair?
No, it's not fair.
You want a free access to Mr. Majumdar, is this fair?
In fact, my lord, legal service authority is waiting for some compensation from men like him. I'm not talking about him, about his senior, my lord.
Yes, Milord.
No, he is he's not seen
My
today.
lord, considering the number of cases
Code
being
number
filed
19, Milord.
in the recent weeks, my lord. So
Sorry?
considering the number of cases on reservation, they.
He's gone for a holiday or
Yeah.
somewhere.
Milord, it can be, Milord. He's there, Milord. It's code number 19. He's on likes. That is the
Acha, acha.
Heavy,
highly
has
authorized.
to be,
Hmm.
heavy cost has to be included.
We'll consider that on the next 116th. 116th.
For admission, item 6 and 7.
The only thing that Lordship had wanted us to verify is regarding the PF amount.
Hmm.
We have verified the amount tallies with what has been
What is the amount? Tell me.
87 lakhs 98,358 rupees 0.75 paisa.
Go through this. After 15 minutes, tell me, all three parties, if you find it okay, I'll sign this order. Yes. We are changing the way we function. The order is ready.
Yes, Your Lordship.
You vet it, and if you find it is okay, I'll sign it. Yes.
Are we entitled to do that, Your Lordship?
Huh?
Are we entitled to do that?
Oh, I'm giving you that. There it is.
Obliged, Your Lordship. Obliged.
You should be happy about it. Is it not time to change the way we function? Yes, Mr. Bora,
Well,
have a look at it.
Endorse it as necessary.
You do whatever you want.
Item 8.
The respondents have, we have challenged that award passed by the Labour Court, my lord. They filed an IA, my lord. Now the law is settled from the date of the award, my lord. They are entitled to back wages.
So you are the petitioner.
I am the petitioner.
We'll dismiss the petition then.
Petition, well, in the IA has been filed only for release of back wages, my lord.
Achha, this matter will require some hearing.
Yes, my lord. Now only IA, my lord, this IA 1899.
Just
Because
1 minute.
17B of the Industrial Dispute Act says that upon filing an affidavit, my lord, this release has to be made, my lord. Back wages only. In para 3 of their IA, my lord, they have stated so.
So hearing the IA and hearing the writ petition will be the same thing, is it?
No, well, IA will be only for release of back wages.
As per submitting the.
Just a minute. Who has filed the IA?
He has filed.
I filed.
What man?
stating that that the respondent has not even paid single penalty date from the date of party date. Requirement was
Can you please place your case? I have not understood anything. Mr. Kuar,
as per
Mr. Kuar and Mr. Bora,
as per 17
there is a acoustic problem in this room. So I am also hearing what you are talking side by side. Can I request you to please, if you can do it outside, come back. I don't know, maybe my ears are too thin.
Live streaming, when we whisper to our juniors,
Yes,
it is being seen in YouTube as well.
yes.
So I think
Please, if possible, huh? Because
we don't hear man, when we whisper.
no, I hear it. I get to hear it.
The same is the problem in the YouTube.
Yes.
as per the provisions of 17B, the workman is entitled for the back wages from the date
Right,
of
so-
award till
You are for whom? You said
and for the workman.
you are for the workmen.
Workman.
There was a reference to the industrial
And this
tribunal.
is good, same is awarded in favor of workmen.
Okay. What was the reference about?
Reference whether his termination was in accordance with law or not.
All right. So what did the tribunal say?
The tribunal says that his termination was not in accordance with law, so tribunal has directed for reinstatement. Being
Right.
agreed by that, we have challenged that award passed by the labor court,
Which is in the writ petition.
which is the writ petition. Now,
Right.
during the pendency of writ petition, they have filed an affidavit
Hmm.
by way of, this is IA 1898. In that IA, they have said for release of the back wages. Now, there are judgments of this court also, my lord,
Hmm.
which says that in case of filing of an affidavit as per provisions of section 17B of the industrial institute, the workman is entitled to back wages from the date of the award.
Hmm.
These are
So that order can be passed.
that order can be passed. My lord. There are, my lord,
Yes.
judgments of this court also, my lord. In the case of my lord Justice Surana, the earlier judgment of Justice Medhi has also been taken into consideration. My lord, that Kakumuni Bhuya, my lord. This is Kakumuni Bhuya, my lord, relevant paragraph is paragraph 13. My lord. The Justice Medhi's order, my lord, paragraph 13.
Hmm.
In the backdrop of the aforesaid discussions and the law holding the field, this court is of the opinion that the present interlocutory application has to be allowed with a direction that full wages last drawn has to be calculated and paid from the date of the award. That is so and so. The amount has to be held to be entitled to the applicant to be released within a period of 45 days from the date of the current liabilities to be released every month in accordance with law. It is, however, clarified that the present order is confined to the issue raised in interlocutory application, namely the date on which the wages under 17B of the Act has to be calculated and has got nothing with the individual merit of the parties in the writ petition. Now, this judgment was also considered in this judgment of Madam Justice Virana, my lord. And here also relevant portion is para 11. My lord.
Para 11.
Para 11. In the light of the above, in the light of the discussions about this, the court is of the considered opinion that the appellant has been able to make out a strong case to hold that the applicant is entitled to full wages last drawn from the date of the award. Accordingly, in terms of the provisions of section 17B of the Industrial Dispute Act, the court is inclined to issue a direction upon the opposite parties to pay the applicant his full wages last drawn to be calculated from so and so, that is the date of the award passed by the learned tribunal in reference case number so and so. The due amount shall be paid by the opposite parties to the applicant within a period of 45 days from today, and the current entitled wage shall be released every month in accordance with law. So that is only my small prayer is, my lord, since the award was passed on 23rd February 2017, my lord. 23rd February 2017, and now it's 23, it will be a huge amount. So for this portion, Lordship will kindly allow us to pay by way of some installments. If that can be accommodated, because 17, 18, 19, 20.
Lordship,
21.
no problem.
You agree? Both of you agree? Why don't you agree to, I'll put it in the
Yeah,
order.
you-
Now onwards, we'll give you the order. You dictate your order.
You must.
No, that is my learned friend has also agreed to
If
it.
you can
Within 6
agree
months-
to something,
within
then
6 months.
you've seen that other matter. See, the court's time is saved. So the order was dictated earlier.
Yes.
There is agreement. So draft has been given, let them have a look. If there is nothing, no mistake in the order or anything required, to
6
say,
months,
then
within
we'll-
6 months.
I'll sign it.
Within
6 months.
maybe.
Two equal installments.
2 equal installments.
All right. You take down. I'm disposing of the IA.
Yes.
Heard Mr. K.L. Gupta, learned counsel for the applicant. Also heard Mr. A. Das, learned counsel appearing for the management stroke opposite party. Full stop. This IA has been filed invoking section 17B of the Industrial Dispute Act, seeking an order for release of the back wages payable to the applicant with effect from the date of the award dated 23/2/2017. Full stop. Earlier, an industrial dispute arising by and between the applicant and the respondent stroke management was referred to the industrial tribunal. Is it industrial tribunal or labor court?
Labor code.
Acha.
Labor code.
Labor court
Labor code.
at Kamrup at Guwahati. Full stop. After hearing the parties, the learned presiding officer of the labor court had passed award dated 23/2/2017 arising out of reference case number
2 of 2013.
2 of 2013.
13, page 89 madam, of the petition. 13, page 89 of the petition.
Reference case 2 of 2013, answering the reference in favor of the workmen. Stop. Consequently, the order of termination of service of the workman stroke applicant was set aside and a direction was issued to reinstate him back in service. First stop. Aggrieved thereby, WPC number 6758 of 2017 has been filed, which is pending disposal before this court. First stop. Next paragraph. By referring to the decisions of this court rendered in the case of Takumuni Bhuya versus management of Apollo Hospitals, Guwahati, reported in 2021, 0 Supreme bracket GAU bracket close 218, as well as a subsequent decision in the case of Nipul Chandra Das versus Punjab National Bank and another rendered in connection with IA bracket civil bracket close 44/2021. Mr. Gupta submits that the management would be bound to pay the back wages to the applicant with effect from the date of award pending disposal of the connected writ petition. First stop. Mr. Das, learned counsel representing the management, has also submitted in his usual fairness that in view of the provisions of section 17B of the Industrial Dispute Act, as well as the decisions rendered in the case of Kakumuni Bhuya Supra and Nipul Chandra Das Supra, the applicant would be entitled to back wages. First stop. However, since the award was passed way back on 23/2/2017, the management be permitted to pay the amount of back wages in 2 equal installments spanning over a period of 6 months from the date of this order. Mr. Gupta has agreed to such a proposition. Full stop. After going through the provisions of section 17B of the next paragraph, Industrial Dispute Act, as well as the decisions of this court in the case of Kakuni Bhuya bracket Supra and Nipul Chandra Das bracket Supra, I find that on an interpretation of the relevant provision of law, the learned single judge has held that the workman would be entitled to back wages even during the proceeding, even during the pendency of a proceeding before the higher forum full stop. Such a opinion was expressed by interpreting section 17 capital B of the Industrial Dispute Act 1947. The aforesaid principle would also be applicable in the facts of the present case. Aforesaid principle in the opinion of this court would also be applicable in the facts of this case. As such, this IA is hereby allowed. The opposite party stroke management of Caledon Tea Estate is directed to release the back wages of the applicant payable as per his last drawn wages calculated with effect from 23/2/2017 till the date of disbursement of the same. The amount can be disbursed in 2 equated installments over a period of 6 months with effect from the date of this order. Thereafter, the workman shall be paid his current dues and his current wages until disposal of the connected writ petition. With the above observation, IA stands disposed of. Yes, just a minute. Yes, anything?
From my side, it is okay.
Yeah, Mr. Bora?
My lord, there is a small,
Yes, okay. Yes, Mr. Kaur?
I'm agreeable.
Mr. Bora?
my lord, there is some, in the order, lordship, regarding in the paragraph, lordship, can you see? Last paragraph, the arrangement will put to the rest of the claims arising by and between the petitioner and the respondent out of this writ petition and the other connected proceeding, including the final order dated 6/10/15, passed by the learned judicial magistrate first class Dibrugarh, Assam in case number 510 C 2003. This is till 510 C 2013, we have no objection, madam. But regarding the second part, as well as the order dated 6/6/2017, we have little reservation, madam. This is pertaining to the daughter's case, madam.
No matter what has happened.
Just a minute. It is no way connected to this, neither she is a party to this proceeding, madam. The daughter has filed a separate case of her own claim, madam, before the court, madam.
No, this order is only between the wife and the husband.
No, my lord,
this order-
even my, no, you are not factually incorrect, my lord.
Just
Just one
I
second.
may be factually incorrect, you correct me later on. Yes.
Little say that.
This is the order, madam, lordship, kindly see. 6/6/2017. She is not a party to this proceeding, neither she has been impleaded by herself in this proceeding, madam. Here only the mother is the impleaded as a proceed for his rights accrued by the DV Act, madam. So mother was a party in this particular proceeding because of right accrued by way of DV Act order, madam. Here, this is a separate case filed by the daughter and the proceeding, my lord. This is the order passed, last order probably, 6/6/2017. This order has been passed under the maintenance case 1/2016, my lord, Hindu Adoption and Maintenance Act. That is the her claim, my lord, daughter's claim of her own, my lord. And that is the direction of the court, and she is not a party to this proceeding, my lord. So we have, neither the court has heard her prayer, my lord. So that her claim is a separate claim apart from the mother's claim, my lord. So that should not be.
Then no order can be passed. You have to.
No, my
impute
lord,
order.
that's again, I will correct my learned friend. That petition has also been filed by the mother on a representative capacity on behalf of the son and the daughter. And because the mother is also working under the Hindu Adoption and Minority Death Act, my lord, both the parents, if they are working, they are equally responsible.
But
This was not filed-
why did you not implicate the children in this proceeding?
No, my lord, this is a matter relating to my termination. She got impleaded, they have not come, my lord. They have not come.
Because,
Even-
no, my lord.
No, it's
Because of that,
termination.
when the termination, they have
Then-
taken the order of staying their proceeding, my lord, the payment of the fine,
Then-
payment of the compensation.
then-
So because of their order, the order passed in the termination case, the amount on the DV Act has been stalled. That's why we have impleaded. He has not impleaded knowingly, and the DV Act is pending, and he has misled the code.
No.
Where is the
I-
that dot order?
I object, my.
He may have the objection, but he has not come up with the clean hands. There is a proceeding DB Act is pending, and he has not brought it in the record. We have to brought it in the record that the DB Act is pending and the payment has been made. Payment, there is direction to the payment, and there's a one more case, that is the case of the Hindu adopted maintenance case by the daughter. There's a separate two proceedings are pending. There is no bar at all. And when she is a minor, obviously the mother can file the proceeding on behalf of the minor.
The daughter is a minor.
At
No,
that
no,
time,
she is
11
not
years.
27 years of age, and
No, no,
this
now-
mother has filed this petition, not the
Maybe,
daughter.
but the that is a different game. That's a different issue altogether. Can the writ petition?
But
can
even
decide-
this can be resolved now.
No. This can be resolved.
If you want, otherwise we
No,
will
no.
on the merit of the case.
Yes, I'm going to merit of the case, but
Yeah.
it's this part, this is separate, but the daughter's part, there's a competent court has passed an order. That part is not in the record. That not part. She was not heard even. How can we give the consent?
My lord, your
From
lordship
the
will
daughter.
take up at 2. I'll bring that copy of that petition to
And
show
the-
that the mother has filed it.
My lordship can see-
Just a minute, don't.
And the lordship can see, this petition they had challenged before the district
No, no,
court.
what is the claim of the daughter?
Daughter, her own maintenance.
So let her continue with the. claim of
Yes, that is
maintenance.
why that's part only deleted, my lord. I'm not objecting. Only my
I'm not
contention
agreeable
is
to that proposal of my friend.
All right,
that part, my contention.
what the
is-
order I will pass is 50% will be given to him, 50% they'll retain.
Yes,
The daughter and wife has to get an order from the competent court. to
Yes.
Get the 50%.
competent court has already passed an order. They have to
That
challenge that
50%
part.
cannot.
They have
be-
went to Supreme Court regarding that. That has been dismissed, my lord. Regarding the daughter's claim, they have went to the High Court, went to the Supreme Court also. This was all dismissed, my lord.
So balance 50% will remain with the employer.
Oil India.
You let them, if they get a mother, the wife and the 2 children, if they get an order from the competent court, then
No,
this
no, that's
amount.
already there, my lord.
No,
For mother,
execution proceedings are not there.
Or mother is already there.
Executing court.
mother is already there. So that part may be released.
No. Then how, from where I will give my daughter?
So
If you
that,
take away
that
the
is, that's a
mother-
different issue. How
Oh.
from you give it to the daughter?
Oh.
No, Mr. Bora, see, that's not a different issue.
Ah.
Please understand. The court cannot deny him more than 50% of what is his retirement due. That cannot be denied in a writ proceeding,
Yes,
right? So whoever, mother, daughter, children, whoever, all persons put together cannot claim more than 50% of the amount. Because this is not a divorce case, this is not a case of alimony.
no.
This is a case of maintenance at the
Right.
most, right?
My lord, the-
Please listen. This is not a case of alimony, permanent alimony, etc. This is not the case.
True, my lord.
The matter is only about maintenance.
Yes, true, my lord.
Now, maintenance matters has got a very, you know it, as a very different parameter.
Yes,
We'll have to see whether the wife is working, whether she has any income of her own,
Yes.
etc., etc.
that is considering.
So
all-
the
no,
proposal
also
which-
give me, the considering all aspect,
Hmm.
the DV Act already has passed an order, final order. That has attained the finality already. Appeal has been dismissed,
Ex parte order, madam.
then you start.
Mr.
What?
Kaur, take your.
Why don't you start?
My
Yeah,
lord,
all right, Mr. Kaur, take your.
So- So,
40
Tell
lakhs
us
are
40
not
lakhs.
happy, greedy wife, one everything.
40. Who's the greedy? Don't use like the word
All
greedy.
right, let's maintain some decorum.
So, why is this greedy word was come up, my lord?
He's not said it to you.
Competent court has passed an order in my favor to grant 40 lakhs long before she has not paid a single penny and I am greedy. My lord, now the second part, there's a one more case filed by the daughter, the separate proceeding. Where from 2017, there's an order pending, not a single penny has been paid by the father to maintain her own daughter. And the daughter is now greedy. Now, this is the order 17, altogether 27 lakhs as per the order of the
and they have challenged this order. It's not that it's not retained the finality. They have came to Guwahati High Court challenging that order, dismissed. They went to Supreme Court, dismissed. Now whether this particular court can amalgamate everything and decide no, will accumulate everything, will give it to the mother without hearing the daughter in a writ proceeding. That's the one question, my lord. So my contention is that the 40 lakhs which has been directed by the DV Act, that may be given to the daughter because that is pending with the interest accrued, and rest of the amount the daughter will claim it separately, my lord. It is her entitled. Whether she is entitled or not, she will prove. Already order is there by the competent court. Execution is pending now. Let them challenge the execution. That's all, my lord. When two court has already decided, and it has attained the finality. It's not that the finality is there.
Mr. Court, then you have to implead the son and daughter.
Yes.
We can't pass this
Yes,
order to.
yes.
Implead.
This order will keep in whole, just like will since the daughter and the son is staying with the mother, she can inform them and I'll formally implead them as a party. Your lordship will fix
What
it.
prevented him to?
No, see.
No,
This
that's all
part
right.
say.
That's
Now
all
We are very greedy people. We are not going to inform.
Yes, yes. So
We are not going to anything.
No, you
Let him
Well,
use their own money.
He should practice what he preach also. It's not
Mr.
that it's
Mr.
a
Bora-
one-way traffic.
Why are you losing your temperament? You are only here for your client's interest.
Yes, my lord. That when did he? What greedy he is used for my client? The
come
who is
on.
living for last 20 years without a penny, and the husband is having the adultery, and he is saying me I am greedy.
Where is adultery proof, my friend? Where is adultery?
This
you
is the
file-
allegation.
you File an application.
Yes, I'll file an application. Your lordship will fix a date, and she will also inform her
On the
children. that-
request of Mr. B.D. Paul and his senior counsel, assisted by Mr. H. Agarwal, appearing for the writ petition. This matter stands adjourned for the day so as to enable the petitioner to file an application for impleadment of his son and daughter in this proceeding. Mr. A. Sharma, learned counsel,
I'll
has
take over.
appeared for the respondent numbers 1 to 5. And Mr. A. Bora, learned senior counsel, assisted by Mr. J. Patwari, is present on behalf of respondent number 6. Register to list this matter along with the IA as and when the same is filed.
But your lordship will fix it, but on 20th.
Can't be
we'll-
fixed, can't, I will not, because it cannot be.
Oh,
You first file your IA.
yes.
I can only say that the matter will be listed along
Only
with it.
thing is that I don't have the present address of my son and daughter because they have vacated the official quarter. My friend will furnish me the address because both of them are staying. I'll include that in the cost title.
You'll furnish it. Let us solve this issue.
Yes, I'm aware of my moral obligation. That's why I have given this proposal.
What,
If
what
they want-
what this court is trying
Yes,
to do
yes,
is
Yes, yes.
solve the problem.
Yes,
And
it
make,
has to be given
make
a quite
them
as much.
enjoy whatever is left.
What is
of-
how can it quite this thing?
See.
And he is saying about the moral obligation. 2013 was you are not paying a single farthing, and you are saying that I am moral. I know my moral obligation.
Everything has been attached by this
In
court.
spite of the court's order, my lord.
And we will maintain the custody of the money.
Of course,
That
of
order
course.
will also
In the
be
meantime,
reported.
the respondent numbers 1 to 4 to retain custody of the dues, pecuniary benefits payable to the petitioner on account of his payable to the petitioner as his retirement dues. Full stop. You file the application.
But this highway will be filed because I don't know what will be happen on the next day.
Hmm.
But this highway will be filed without prejudice to any of my rights because it's not a concession that I have given to them now.
We'll see, Mr.
Yes.
Kumar, you
Yes,
file the IA.
yes, ma'am.
Obliged, my lord.
This is wrongly listed, my lord. The review petition.
It is submitted at the bar that the wrong case record has been sent to the court today. In view of the above, register to verify and list this case again after 10 days along with the correct record.
Obliged.
Wrong record has come today.
Item 10. Such a request for passable in the time being.
But you are pay for 3 weeks time to file an affidavit. The instruction that Lordship have kept on record, Lordship, and we place it on oath, Lordship. On the
What is
last
this
occasion, Lordship.
What is this matter about?
Promotion
Such a
matter.
promotion matter, your lordship.
The affidavit will be necessary in promotion matter.
Lordship, affidavit we have already filed, Lordship. I pray for filing of an additional affidavit, Lordship, on the updated instruction, Lordship.
2 weeks will grant her. 2 weeks.
3 weeks time, Lordship.
Shorter time, 2 weeks, your lordship.
All right, 2 weeks. Yes, Miss
S. Sharma Hazarika.
S. Sharma
Hazarika.
Hazarika is present on behalf of the petitioner. Miss D. Bora,
Hard for us.
R. Bora, Learned Standing Council, Agriculture Department, Assam, submits that in view of the developments taking place in the matter, an additional affidavit is required to be brought on record. First of, therefore, some time be granted for the same. First of, after taking note of the request of Ms. Bora, this court is inclined to grant 2 weeks time to the department to file additional affidavit. Now let this matter be listed again after 3 weeks by tagging the affidavit, additional affidavit of the department, if the same is brought on record within 2 weeks from today.
Obliged.
If you don't bring it within 2 weeks,
No,
gone.
we'll file it.
Item 11.
My lord, this is regarding the appointment of VDP Secretary at Durgamari village in the district of Bongaigaon, my lord. My lord, the village level committee selected me as the first choice. I was a VDP Secretary for last 5 years, and I have done tremendous admirable jobs, which is also admitted by SP. But 208 persons supported me, 11 persons objected me. That very person who was supported by only 11 persons, they have been appointed bypassing the decision of Gaon Sabha, and SP said that it is done as per the request of MLA. So kindly see, and record was called for. Record also says that I was the top priority, and order is passed against me without showing any reason. Kindly see Annex 10 of the writ petition. S29. This is +29, Durgamari VDP, Secretary PRL Sarkar. He had the support of only 11 persons. I had the supports of 208 persons. These are on record. Now, SP has filed affidavit, my lord. SP clearly says, my lord, SP's affidavit may kindly be seen. Para 5.
What is this matter? What?
Lordship.
This is about what? Some VDP,
VDP, Village Defense Party, my lord.
Indian Defense Party.
My lord. The
Then-
tenure is already over of the petitioner. He was engaged on 23/5/2016, and his tenure was over on 6/2022. The paragraph 4 of our affidavit, the affidavit filed by
No,
the
1 minute, what? 10 year as what?
5 years.
10 year as what?
For
As the MLA,
Secretary, my lord. For
Secretary.
VDP, my lord.
Secretary of the Gaon Panchayat.
Village Defense Party.
No, I am asking 10 year, who decides the 10 year? Under what provision is the 10 year decided?
It is as per the village, as per the rule 19 of the Assam Village Defense Organization. The committee.
Where is that? The rules are there in the
Lordship, we will give an annex, but in the affidavit we have mentioned, my lord, paragraph 5.
rules have been annexed.
Not annex, but we have mentioned, and the statement has been given, my lord.
Mr. Mahmood, you have the rules.
The rules I do not, it is not found, but I have the act. That is as section 5 to 19, all these things are there. My lord, my learned friend has said one aspect only. Definitely, tenure is 5 years.
No, Mr. Mahmood, you see, the problem is law is what matters in the High Court. Only facts will not do. We have to
No,
see
law,
what is-
law I am submitting, my lord.
Yes.
There are persons who are working since last 45 years. After
First
5 years,
question is, for how many years and when was he?
yes, I am submitting, I am admitting, man. I am admitting that tenure is 5 years. After 5 years, again Gav Sabha sits
Hmm.
and they select the persons. So in this manner, my lord, 45 years, continuously many persons coming, that is on record. Kindly see my affidavit.
So
I have-
where is the rule which decides that procedure? That's what I'm asking. Without that, I'm not going to write any order.
That is, kindly see from section 5 and 18, maybe same. Rule is not available. It is also not on the internet also. You did not find it.
Where are the rules?
Lordship will produce the record, Lordship. I did
Record
not
is
find
here,
it.
I think.
No,
Record are-
record is not with us right
And it
now.
was also, my lord, may I kindly see the order passed by Honorable Justice Mr. Michael, that was passed on 23/6/22.
After it, we have filed the affidavit, actually the instruction that was, it was recorded, the
The
record.
record came, so I know
But
record
it was
came,
not with us right
but
now.
at that time they took some dates. My only prayer is this, my lord, tenure is 5 years, there is no dispute. But after 5 years, the Gav Sabha sits again select the person. So in this manner, some persons are working since the 45 years, that is on record. I have brought on record that why you are filing affidavit in reply. That affidavit reply was filed on 21/9/22. Kindly see that. So this person, their list I have given, that may be sent as 52 my lord, of my affidavit.
I have not understood anything, Mr. Mahmood, but you finish off with whatever you want to say. I have not understood anything. What is the law? What is the rule? What rule says it will be for 5 years? What is the procedure? When was this person appointed? Then subsequently, was he again reappointed or
Not
re-elected?
reappointed.
Then how can he
Irrespective
be?
of the decision of the Gav Sabha.
No.
Correct.
Gav Sabha selected me as number 1 in serial number, and 11 persons supported the private respondent, he has been appointed. And that too without showing any reason by the SP. It is said that MLA wrote a letter. But thing is this, SP also admits that I have discharged tremendous works in my area. That is evident in his affidavit, para 5. So tenure, my lord, though we could not find out the rule, we tried, but it is admitted fact. But it is also on record that 45 years, one person is considered, not to one person, so many persons, that may be seen in my affidavit. I have given their names and how many times they are working. All these things are in my affidavit. Kindly have a look to my affidavits. 21/9/22. Yes.
Mr. Mahmood, I'll not be able to write an order only on who admits what and who doesn't admit. Because these judgments of ours become precedent. Your submissions are not precedents. Our orders are precedents. Binding precedent for the government to follow. We
That may
cannot
not-
write out an order unless the proper facts and materials are placed before the court. So if you are asking for an enforceable right, what is the enforceable right? You have to tell us.
Well, these things were also raised by my learned friend on other day, and the long order has been passed on 23/6/22. There every aspect of the law has been discussed. 23/6/22. Can listen.
Lordship may grant me some time, I'll produce the record. Record is necessary, my lord, because there is nothing annexed in the affidavit also. What happened in the public meeting?
Just
Only
a minute, let him fit 23/6.
23/6/22.
So the learned judges also called for the rules.
Lordship. Lordship, I'll produce the records.
Where are the rules?
Yes, Lordship.
You don't have the rules.
Rules I don't have right now, but
Mr. Mahmood, without the rules, no order can be
My lord,
written.
my
This is what is reflected in the order you are also relying. 23/6/2022, the learned judges also said,
my
we
lord.
require the state respondents to provide the rules that may have been framed. Without the rules, no decision is possible in this matter. That's what is my view is. Because your claim has to be assessed on the basis of the rules. How do we write a judgment otherwise?
Lordship may grant me 10 days time, I'll produce the records along with the rules, my lord.
Maybe on Friday, my lord, because Lordship has had the matter. The rules some will try, actually we also tried, but internet it is not
Records
available.
also required what happened in the public meeting on
But
that day.
one thing, my lord, I remember subject to correction. Perhaps one copy of rule I had given it maybe in record. Subject to correction, because earlier,
No, you have given copy of the act, not the rules.
no, earlier time, so that in record, I slightly remember that I have given that also.
No, it is the act as well as the notification. Oh, yes. Assam Village Defense Organization Rules 1986. Yes, it is there. There in it.
I have slightly remember that.
All right, so you ready to argue finally today?
Well, the matter is very simple. SP also agreed that I was recommended first. So, my lord, there must be a reason order.
Where are the records?
Records, Lordship, I don't have right now. Also, kindly give me 7 days time. I'll produce record along with the rules also, because the affidavit stated that on that day, the public meeting was held, and public has nominated 2 persons. Name of the 2 persons, one is the petitioner, one is the private respondent. So the tenure of the petition was over, and after examination of all
The
aspects.
tenure means what? If he is appointed, then again he gets a tenure.
Yes.
Yes, 5 years is already over.
Correct. If he is
My
appointed again, then he'll get another 5 years.
My lord, but the other person was appointed, the private respondent.
That's what he's saying. His merit wise, his client was found to be better.
It is all the.
That's why the record of the public meeting was necessary. What happened in the.
Where
public
is that
meeting.
record?
Record I'll produce, my lord, but these are not in the.
All right, we got the rules. We need the records, and then we'll pass a judgment on
My lord.
Wednesday. Or Mr. M. Mohammed Learned Counsel appearing for the petitioner. The petitioner is seeking an order setting aside the appointment of the private respondent as the as what in what the secretary
Secretary of Durgamari VDP
as the secretary of the Durgapuri VDP
in the
and
district of.
a writ of mandamus directing the respondents to appoint him. First of such a prayer has been made on the ground that the selection committee had found the petitioner to be more meritorious than the respondent, than the private respondent. Full stop. Notwithstanding the same, no appointment order was issued in favor of the petitioner due to reasons other than bona fide. Full stop. Verification of the aforesaid claim would require inspection of the records of the selection committee. Full stop. Since Ms. Bora has prayed for fixing this matter again on 22,
Lordship may kindly fix the matter on 23.
23, 23, 23,
Let it be 22, my lord, 23.
23 to 2023
As a part
for producing the records. Registry to list this case again on 23 to 2023 as a fixed matter.
My lord.
This bench only it will come.
May I
It
accept my pardon, madam?
will come,
Deeply
it will come.
obliged.
Don't worry, it will come.
Oblige, my lord.
23, 23 to.
And one thing, I am taking this rule and after Xerox I will give again.
Yes, give it to you. Yes.
May I please, your lordship? Now the petitioner was appointed as chairman of the SC Development Board, Dhubri, madam. But on the last occasion, my lord, the respondent side was supposed to file the affidavit in opposition. My lord, before that, my lord, he was supposed to, there was a direction on him to supposed to supply me with extra copies. As of today, I am still waiting for the extra copy to send it to the department.
You have not given extra copy.
Extra copies, there is a direction in the order itself, on the last order, madam. Even, my lord.
One is 3 copies.
Extra 3 copies.
You have not given him. Mr.
29/7, na? This is not my phone. It was given one. It is government advocate, na?
Yeah,
GA. You have to give a standing counsel.
Then I will furnish copy by today itself.
You are appearing as what?
Standing counsel, madam.
Standing counsel of what?
WPT, madam.
Achha, your name please?
A Rashid.
Mr. A. Rashid, learned counsel is present on behalf of the petitioner. Mr. R. Dhar, learned standing counsel, WPT and BC department. That is respond numbers 1, 2, and 3. Herein submits that due to want of extra copies, necessary instructions could not be obtained by him from the department. Full stop.
My lord, I am appearing for respondent number 6.
Achha. Miss M.D. Bora, learned additional senior government advocate Assam is present on behalf of respond numbers 4 and 5. And Mr. D.K. Roy, learned counsel for respond number 6. Since the petitioner's counsel has assured this court that the extra copies of the writ petition shall be furnished to the learned standing counsel WPT and BC within 2 days from today, this matter stands adjourned for three weeks so as to enable him to obtain instruction and file affidavit. Mr.
Date may be fixed.
It will come after 3 weeks. Yes.
Look, I have received some instructions from the Secretary Health. Look, they informed me that I have also spoke to the Superintendent of GMCH. Look, my instruction is that within a week from today, let the petitioner, the victim boy, appear before them, and a medical team will examine the feasibility of. Otherwise, there is a scheme, Assam Arogya Nidhi, under that particular scheme. One artificial limb can be provided, but first they want to examine the person.
I'm agreeable, my lord, provided a date and time is fixed, so that my lord, those limbs provided under the scheme, my lord, even before I've submitted before this court, most of them are cosmetic limbs, my lord, which do not have any movement. They're only for cosmetic purposes. such a limb.
The cosmetic limb will not be of any use. Are you proposing a cosmetic limb?
No, at this stage,
All right,
I
you
don't-
see, we have to have a little patience here.
true.
In
At least-
in a big hurry, you can't do these things.
Yes, sir. Let him go appear before the superintendent manner. I have talked to the superintendent GMCH. He said that let him come. At least they will examine the feasibility, and if it is feasible under the Assam Arogyanity scheme, there is a scheme about one artificial limb can be provided, and they used to provide it at the Narayana Hospital at Bangalore. They will arrange the subsequent things. First, they want to examine the person.
The boys travel along with an escort. He stay,
Yes.
whatever cost of treatment, artificial limb, everything the state.
Not they said that expenditure will be incurred by the state. Whether stay and all these things included or not, I don't know. But I'll have to just waiting for the written instruction. First, let him go. Let him go.
Let them assess, my lord.
Let them assess.
Acha, Ms. Chaudhary, would you like to say anything?
Lordships, my
At this
instructions
stage-
are very dismal, unfortunately, that they have examined the matter. And they've said that where he has been amputated, it's not possible. Their view is that it may not be possible to give him mechanical limbs. Only cosmetic limbs may perhaps be given to him.
That is whose view is this?
Lordship, the Jaipur people, this is the, it is called Bhagwan Mahakir Viklang Sahayata Samiti, where they are making these artificial limbs and all that. So the Asalsa.
Yeah, that has been the disturbing thing. Why they have to amputate the hands, both the hands at that level?
It's very dismal, Your Lordship, unfortunate as it is. That's what they have said, that it may not, perhaps it may not be feasible. to give mechanical limbs.
I was very disturbed when I saw the picture. One doesn't know whether this amputation at that level was avoidable or not. You can't even take a view because you don't know there could be strong medical reasons, but both the hands are the same place.
Same place.
Same place, unfortunate. as it is.
Very pathetic one of the pictures.
All right, we'll see if we, whatever support we can give, otherwise the matter will be confined only to you have filed your affidavit. So that employment thing is on. And then the next thing is if the prosthetic limb doesn't work out, then we'll close it with the assessment of further compensation, whatever. What else?
Has to be a Indian prosthetics won't work, my lord. I have done my research. This Jaipur place, my lord.
No, that is what Ms. Rakhi is saying.
Not going to happen.
There are other, my lord, prosthetics, German prosthetics, they are a bit expensive, but now the technology has advanced to that level, my lord, where
Expenses mean how expensive?
it can range anywhere from 20 to 25 lakhs, my lord.
No, but there is no guarantee that this will work.
There is no guarantee. What I was told by the father, that he has to turn 18 first. Only then those prosthetics, whether it will work or not, that can be decided. Now he's too young to take the weight of.
No, what Mr. Nath is saying, you see, that appears to be logical because we have to proceed with the experts now.
Yes.
The court cannot
Absolutely.
take a decision. If there is a bottleneck, if there is some roadblock, then the court can pass orders by clarifying it. But now, since the medical team is willing to examine him, let us first have what their opinion is. And maybe there is something, maybe they may come up with something. If they come up with something well and good, what the court wants to see is that to what extent you can make him, independent, not dependent on his parents. And then they will see what compensation is required. That is the approach of the court. Is there any other approach that is required, Ms. Chaudhary?
At this stage, Lordship, this seems to be a good feasibility that let him get examined. If they're willing and able to support him financially and send him to Narayana, that is a very good option. Let him go and get the requisite this thing. And thereafter, Lordship may keep the matter pending. Have a look at what happens there and then decide on the quantum of compensation which has to be given.
And the job part is there.
Yes, my lord.
No, I'll not dispose of this matter and it will not be released from part head
Lordships.
till he gets the job. Mr. Chuti, you may be very clear about it. Till he gets the appointment order, this matter will neither be disposed of nor released from part one.
Father is working, my lord, in that particular
No,
department.
that's all good.
My lord.
That's,
And he knows, my lord, that how the matter is proceeding.
no, that's fine, but
And
will not dispose it, neither release it. When is he turning 18?
My lord,
I think two more years to go, I think.
2 more years.
4 years.
Oh, that's-
as on 1/9/2022, he was 16 years, 2 months, 17 days, my lord. So my lord's 1/9/2022. There's one more year, one more year. And so
All
far,
right, otherwise we'll find a way to monitor it, but the point is, let him now go. Acha, I'll dictate the order. Can you just tell him the date and time?
Lordship.
Later on, you tell him, ask the superintendent and give it to him. Rest of the part of the order I am dictating.
Malum.
All right.
Lordship.
Mr. Chaudhary, you be in peace now. You will have things to do a little later. You see, this court wants to make it an exemplary, order, so that these departmental people also wakes up. We can't, things can't be so casual. We are developing at a fast pace as a nation, as a state. If this was the state of affairs in a country like USA, UK, there would have been a massive repercussion. Massive repercussion. It can't just be there. So somebody must feel the pinch. That's the idea. Mr. P. Mohanto, learned counsel for the petitioner, is present. Mr. D. Nath, learned senior government advocate, Assam, has obtained instructions in terms of the order dated 24/1/2023, passed by this court, and submits that. As per the information received from the Secretary to the Government of Assam Health and Family Welfare Department, the government is willing to provide all,
And the superintendent also.
as well as the superintendent of the Guwahati Medical College Hospital, Guwahati. The government is willing to provide all assistance for making available a mechanical artificial limb to the petitioner, subject to his conditions permitting the same. First up, on that behalf, the government will also make arrangements for travel.
Under the Assam Arogya Nidhi, there is a scheme called Assam Arogya Nidhi.
Mr. Nath submits that under the Assam Arogya Nidhi scheme, all necessary assistance may be provided to the petitioner. Full stop. However, the aforesaid process cannot begin until a medical team at the Guwahati Medical College Hospital makes an assessment of the exact condition of the petitioner and the facilities that can be provided to him. Full stop. As such, Mr. Nath submits that the petitioner may appear before the medical team headed by the superintendent of the Guwahati Medical College Hospital on any day convenient to him. Full stop. Ms. R. S. Chaudhary, learned standing counsel, Assam State Legal Service Authority, submits that since a prosthetic limb for a cosmetic purpose would be of no use to the petitioner, hence the proposal made by Mr. Nath appears to be reasonable. Mr. J. Chutia, learned standing counsel, KAC, has maintained his stand as reflected in the affidavit that as soon as the petitioner attains the age of 18 years, he will be provided with a job under the PHE department, under any department, government job, under permanent government job, under any department. Permanent job in any of the departments coming under the council. Full stop. Mr. Chaudhary, Mr. B. Chaudhary, learned standing counsel, FPDCL, is also present. Full stop. Having taken note of the submissions of learned counsel for both the sides and as agreed to by the petitioner's counsel, it is hereby provided that the petitioner, namely Master Pragyan Bansal, may appear before the superintendent of the Guwahati Medical College Hospital at Guwahati on dash AM for carrying out an assessment of his limbs in the light of the observations made above, full stop. Release this case again after 3 weeks. In the meantime, the progress be intimated by Mr. Nath, Learned Senior Government Advocate, Assam.
The job part later, it may require some modification because the affidavit says subject to his educational qualification and suitability. That has to be.
That's why I said I'm not disposing of this matter.
That has to be modified.
Yes.
Your Lordship, departmental relevant documents is needed to be produced, Your Lordship. That has not been received, Your Lordship. So kindly
Why it has not been received almost a month back?
1 week time will be granted, Your Lordship.
What will happen in 1 week?
Lordship, may I point out one thing, my lord, otherwise, Lordship, whatever required document, that is already available in a way of my lord LCR, because that there is a reference case before the industry to that record is already there, my lord. I think that is sufficient to suppose proceed this matter. If anything more required, then Lordship.
What is this order 19/1/2023?
Last part, my lord, respondent shall produce the departmental proceeding.
So there is an order from the court to produce the departmental proceeding. This is not a part of this record.
My lord, so far the departmental part is concerned, my lord, evidences and other thing, my lord, and termination letter, so everything is there, man.
What record you want to produce?
Your Lordship, that I am not aware, Your Lordship.
Oh, you don't even know what record you want.
Lordship, already I know, Your Lordship, the facts, Your Lordship.
Then let us hear the case.
Lordship, then
It is required, my lord, then, my lord.
Yes, what is the matter about?
I'm giving the nutshell of the facts, my lord. What happened, my lord, the petitioner is a laboratory assistant, my lord. Working on the Nummulikal refinery, my lord, one of the hospital called Vivekananda Kendriya Hospital. Now, what happened, my lord, on a particular date, my lord, his basic duty was to attend laboratory in order to, my lord, test the patients, my lord, for certain whatever disease that is in record, my lord. But what happened, my lord, on particular date, my lord, the petitioner was asked to attend the duty.
What is the date?
My lord, that date is, my lord, 28/3/2009. Now, the ambulance was sent to his quarter, but that point of time, since he has earlier disease, my lord, migraine, my lord, he was suffering from that migraine. He was not in a position to, my lord, attend the my lord, that test. Therefore, informed to the ambulance driver to intimate to the concerned doctor about his inability to attend the test, my lord. And accordingly, my lord, that ambulance driver intimated orally to the concerned doctor, and thereafter substitute arrangement was made and test was done. Now, this is only the singular report on the basis of which an inquiry was initiated. Now, while that inquiry is initiated, my lord, the inquiry officer is the same person who also presented the case on behalf of the defendant. This is another issue, my lord. Now, their basic allegations are 3 levels, my lord. First is that he is a habitual, my lord, offender. In the second thing is that, my lord, there is subordination of the, my lord, duty which has been imposed upon him. Third is that he has not followed the directions of the superior, my lord. Based on that, my lord, that inquiry was conducted, and in course of, my lord, inquiry, evidence were led. Now, while that evidence were led, my lord, the inquiry officer himself represents the prosecution side also, my lord, and all evidence were collected on his behalf. And, my lord, afterward, a conclusion arrived at on the basis of inquiry report that since that all allegations has been established, therefore, a proposal was made for dismissal from his service. Now, based on that, my lord, that final decision was communicated to the petitioner, dismissal from service. And afterward, my lord, this matter was referred to the industrial tribunal. Now, industrial tribunal look into the all aspects and arrived at a conclusion that whatever decision that has been adopted, that was upheld, and against this matter, this instant, my lord, petition be applicable. Now, lordship, there are three grounds here, my lord. First ground is, my lord, inquiry officer and presenting officer are the same person. Second ground, disproportionate of punishment, my lord. And third thing is that, my lord, so far these allegations are concerned, centrally it is clearly stated willful disobedience, my lord. The inquiry report nowhere states about willful, my lord, disobedience, my lord. It's a case of some assumption they have made out that on the basis of it is found that he disobeyed the directions filed by the superior, my lord. Lordship, at first, Lordship, I would want to go some of the documents, my lord.
So what is the law says? Inquiry officer cannot be the presenting officer.
Because ultimately, my lord, that objection we have
No,
already raised.
that is your submission or there is any authority?
Authority, there is also that reference we have also.
Let's see the authority.
My lord, in judgment also. My lord, page 38, my lord.
What is there in page 38?
My lord, page 38, paragraph 14, 15.
You are referring to some citation.
My lord.
What is it? What is the citation?
My lord, this citations is, my lord, 1997 GLR 2221.
1997 3 GLR
221.
Are you referring to this
Yes, my lord.
page number?
Yes, my lord. Page, I have also indicated the page, my lord. There.
What is the page number?
Page 38, my lord.
Page 38 is a part of a judgment of the
Yes, ma'am.
Bombay High Court.
Yes, ma'am. Guwahati High Court, madam.
No.
Lordship. Yes.
Give it to me.
I'm presentation, my lord. Yes.
Then you correct it, Mr. Samaria.
Right.
On the request of Mr. Samaria, learned counsel for the petitioner, as well as Ms. P. Das, learned counsel for appearing for the respondents, this matter, hearing of this matter stands adjourned for 2 weeks. On the next date fixed, Ms. Das to produce the records as called by the as called for by the order dated 19/1/2023. Passed.
Deeply,
Passed by
deeply.
this court.
Deeply.
Item 17.
Make clear question. This matter relates to promotion matter,
Relates to?
promotion matter. The petitioners before lawsuit. Petition number 1 to 5. They were initially appointed as master workers. Subsequently, my lord, their services were regularized by order dated 27/10/2005. And the petition number 6, he was initially appointed as worksite worker. And his service was regularized on 25/3/1995. 2005, I'm sorry, my lord. 2005. But despite being qualified, my lord, their cases were not considered for promotion to grade 3 post. So my lord, they approached this honorable court by filing a writ petition. And this honorable court, my lord, must will find that order at page 70 of the writ petition, my lord.
So now the qualification has been raised.
My lord,
What is the qualification now?
now it has been raised to my lord graduate.
And your clients are all matriculate,
No, my lord, they are higher secondary passed.
higher secondary pass. So on that ground, they have not been promoted. All right, so when was the qualification raised?
It was my lord 2010, 2015. And then when was-
2015.
My lord.
What is the date of the notification?
my lord. Amendment was done on 15 October 2015, madam.
Is it available on record?
My lord, it is not available. I have given the compilation of the ministerial rule, my lord,
Okay.
along with the amendments, my lord.
Achha, can you tell me the page number?
Page number, my lord, I have not designated, my lord. I have the flag mark, my lord. Because initially my lord, amended in the year 1994. Initially, it was higher secondary pass. In 1994, it was reduced to HSLC pass. Subsequently, my lord, in 2015, it has been announced.
So there are many such cases. Some decided case law must be there in this. Whether by enhancing the qualification, people whether who are already in service, whether they can be denied promotion or not. No decision on that. There are a number of cases. This has come up to the court here.
My lord, now they have come up with a plea,
Hmm.
respondents, that my lord, the petitioners were regularized against the personal post. So my lord, they are not entitled to promotion. That is the.
Who is for the respondent here?
Not appeared earlier, my lord.
Who?
From my advocate, my lord. Mr. Nath. He not. Earlier he appeared, my lord.
No, you have to send an invitation letter, otherwise they don't come.
Under the-
Have you got printed invitation letters? Yes, you are appearing in this case. PW.
Lordship, here the writ petitioners were initially engaged as master worker.
Hmm.
Subsequently, in the year 2005, their services were regularized. Lordship. They were regularized against posts created against their name, Lordship. So these posts are personal posts,
Hmm.
and the post, meaning thereby that post will get abolished as soon as they relinquish the post in whatever manner, Lordship. Lordship, the point of law here is that whether a person who has been regularized against a personal post can be promoted to a regular cadre post. And that issue has been settled by our division bench, Lordship.
What does it say? It cannot be.
No.
Where is the judgment? Division bench judgment?
It's a judgment of Dilip Kumar Talukdar, Lord.
Next, in the affidavit, they are annexed.
So have you read this judgment?
Yes, my lord.
Then if your case is covered, then what is there to be decided?
In the division bench case, my lord, it is said that those posts were, my lord, they were regularized against, my lord, non-cadre post. But in the regularization order of the petitioner's, my lord, the petitioner number 6, Procedural 5, his service was regularized for 2005 against permanent post. The petition number 6. The other persons, my lord, 1 to 5 petitioners, they were certified against personal post. But in their regularization order, it is clearly mentioned that they are
Just switch it off.
1992. Then, my lord,
1 minute, let me get the on appointed on 29.
29 to 1992.
Where is the order? The order of his
My
appointment.
lord, is 32, my lord. Is 32. He was appointed as officers work Chokidar, my lord. Then his service was regularized, my lord, page 33, my lord. That is a retirement vacant post. That is not a personal post. my lord.
So other 1 to 5 are personal posts, that you agree.
Yes, ma'am.
So that's your case. And where is the judgment? Do you have a copy? That division bench judgment?
Division bench judgment, my lord, they have annexed with their affidavit, my lord.
It is there in the affidavit.
In their affidavit, my lord. Page 8 of the affidavit, my lord.
And which is the relevant paragraph?
Paragraph, my lord, paragraph 8, my lord. 8, 12, 8 and 12, my lord.
All right, so Mr. Nayak, only petitioner number 6, he says, and prima facie it appears that it was a vacant post.
Lordship, kindly see page 29, Lordship. This is the regularization order in respect of the other petitioner. Lordship, may kindly
No,
see
other
the-
petitioners, he's saying that they
No,
don't.
I'm just setting it, Lordship.
Yes.
In pursuance of government order number so and so dated 39/2005, as well as finance department concurrence number. Lordship, and Lordship will see the regularization of the petitioner, petitioner number 6, Lordship, at page 32. It was issued by the executive engineer on the law. And in fact, Lordship, executive engineer is not the appropriate authority to regularize the service of any person. Lord.
No, but is he a regular employee or not?
Lordship, in other cases, Lordship, we have generally mentioned that they were regularized by following the policy of 2005. Lordship, in this case, Lordship, I have to take specific instruction, Lordship, what kind of regularization it was.
No, but the document says that it was against a vacant post, whether even if the executive engineer has passed the order, that will not take away
No,
the regular.
executive engineer can appoint somebody on work source basis, again, the sanction post also. In that case, also regularization is necessary, Lordship, with the approval of the authority.
That is correct. He is referring to page number 33.
Yes, that is the I'm referring. That was by the executive engineer.
The question here is the regularization took place against the vacant post created after retirement of Sri Harendra Kumar Das.
The vacant post is there, but the appointment was work source basis. On the work source basis also, I can engage somebody against the vacant post. And that becomes a case for regularization, Lordship.
But then
Lordship,
regularization is not against a personal post. That's what he's arguing.
No, Lordship, but as the executive engineer is not the appropriate authority to regularize, whether it was done with approval of the higher authority or not. That's
Supposing it is found that it was not done, then petitioner will be treated that he was not regularized.
No, Lord.
Then?
No, he will not be treated as regularized, Lordship.
Oh.
He is entitled to scale, Lordship, as he was working on work source basis. He is entitled to scale like any other regular employee.
So what about the others? They will be treated as regularized, but not the petitioner.
In that case, no, Lord. Lordship, in 1995 also we had a policy, Lordship. They are also where all the persons engaged, regularized by following that policy.
No,
Lordship.
Mr. Nayak, whether the petitioner is regularized or not, we will answer it just now. They will be treated as regularized. So only question is, if they were regularized against posts which are created personal to them, you may have a point. And that issue has been decided by the division bench judgment. Only exception here is about petitioner number 6, because the order itself says his regularization was against a vacant post, which arose due to retirement of one person called Harendra Kumar Das. So this shows that the regularization was not against a personal post, but against a vacant post.
Yes, Lordship.
So if that happens, then the plea that he will not be entitled for consideration for promotion.
No, Lordship, what I am submitting, Lordship, even without regularization, I can be engaged against the sanctioned vacant post. And that may become a case for the petitioner to claim regularization. As I am working against sanctioned vacant post, regularize my service. But that requires the approval of the higher authority, Lordship, government. Here it is not there, Lordship.
What is the pay scale? Is he drawing a pay scale?
Yes, Lordship, being a workforce employee, he will definitely draw pay scale.
Regular pay scale?
Yes, Lordship.
No,
Just
no
like regular.
action is required.
For workers, for the workers employees to get regular scale, Lordship, no sanction, no approval is required, Lordship. If the post is there, he will get the regular scale.
Approval has come after 2021.
No, in 95 also it was. 95 also it was a government policy.
Finance approval.
Page 29, that is why, Lordship, I was referring to page 29. It is with the approval of the government.
In case of others, where is the order of approval?
29, Lordship.
The name of petitioner number 6 is not there.
No.
Page
This is pursuant to policy of 2005, Lordship. And here the petitioner was brought under regular cadre in the year 1995, Lordship. 1995.
That one instruction only, whether he was actually regularized or he was just engaged against a regular vacant post, Lordship. Lordship will take up next week, Lordship.
Well, initially he was appointed as workers worker, my lord. Workers are entitled to regular scale of pay. By this order at page 33, his service was regularized.
No, but he has a point. Executive engineer can communicate an order. He is not the authority to regularize.
In case of grade 4, my lord, executive engineer is the authority, appointing authority, my lord.
Approval is, even then approval is required,
No,
Lordship.
no,
Page
but
29, I am placing, Lord.
Is the government's approval not required? Can the executive engineer function without being authorized by the government?
That is, he should be authorized. That is true.
That is what he is saying, that it was passed unauthorizedly.
Then, my lord, record of that order will have to be.
No, that we don't know. You argue. Today you want to argue. Tomorrow you want to argue. We'll give our verdict. We are not getting into a discussion or debate with the bar on this. You are ready to argue today?
No, my case is that, my lord, this is the order by which he was regularized. And since then he is working. And therefore, my
All right,
lord,
Mr. I.H. Silka, learned counsel for the petitioner, has fairly submitted that insofar as the petitioner numbers 1 to 5 are concerned, it may be the case that their services were regularized against personal posts, which would stand abolished after their retirement. And in view of the decision of this court rendered in the case of Dilip Talukdar and others versus State of Assam and others, reported in 2017 bracket close 3 GLR 376. It is no longer res integra that persons regularized against personal post cannot claim to be in the feeder cadre for promotion to the next higher grade. However, according to Mr. Saikia, the petitioner number 6, namely so-and-so, was regularized against a vacant post arising due to the retirement of one Sri Harendra Kumar Das by wide order dated 25/3/1995, and therefore the respondents would not have denied a fair consideration to the petitioner number 6 for his promotion to the next higher grade. Responding to the above, Mr. Nayak P. Nayak, Learned Standing Counsel, PWD Assam, submits that the executive engineer is not the authority to regularize the service of a masteral worker without the approval of the government. And unless the government approval is there, his order of regularization will be null and void. Mr. Nayak, however, prays for a week's time to obtain specific instruction and appraise this court as to whether the order dated 25/3/1995 was issued after obtaining approval of the government of Assam. First up, since the aforesaid aspect of the matter would have a crucial bearing in the outcome of the writ petition, I am inclined to grant 1 week's time to the learned departmental counsel to obtain necessary clarificatory instruction. This matter is therefore directed to be listed again on 23rd of February 2023 as a fixed part of matter.
May I please, Your Lordship?
Yes.
Lordship, this matter relates to dismissal from service. The petitioner was a cook in Sima Suraksha Bal. He was given an outpass from 1300 hours to 1600 hours to buy a cell phone. When he had visited the market, he had to go for nature's call and he could not return back to the party.
the party left him behind and came back to the headquarters. After that, a search party was sent and the petitioner was brought back. After bringing him back, the party commandant filed a complaint against him, to which and he was put under open arrest, Lordship.
He was put under?
Open arrest, Lordship. Means he could not leave the his duty place, Lordship. So a summary force court was also held on 30/3/2017, where this order was passed. But my prayer is that he may be reinstated, and as he had some loans and he have also apologized for his behavior, he may be reinstated, Lordship.
No, that we can't say. We'll only
Yes.
see if the order is arbitrary or not.
Yes, Lordship.
If it is arbitrary, we'll
It
set
may be
it
set
as, if
aside,
it is not
Lordship.
arbitrary, it will be maintained. Whether he should be reinstated or we are not concerned with those things.
This order, the order challenge may be set aside, Lordship.
Why? Set aside on what ground?
Lordship, first he was not, he did not examine the, he did not cross-examine the witnesses. Lordship, he did not have that idea what would happen if he did not cross-examine the witnesses. Lordship, and he has apologized for his conduct, and he had also some loans, which he otherwise could not. Otherwise, he could not make the payment of the loan, Lordship. So at least it may be considered, Lordship.
So, Mr. Sharma, what is your submission? Is it a submission that he could not pay the loans, so set aside the order of dismissal and reinstatement? Is that your submission?
No, Lordship.
Then what is your submission?
My submission is that, Lordship,
Yes, don't be afraid. You tell me what you have prepared. Are you prepared to argue the case? So
yes,
finally,
Lordship.
don't be nervous. You want some water?
No, Lordship. Thank you.
Don't be nervous.
Lordship, we have apologized for his his conduct, and Lordship, his past record was also taken into consideration while this order was passed of his dismissal. That is
Mr.
my
Dev
submission.
Chaudhary, it doesn't seem he is clear about his case. But the difficulty is we can't write a judgment the way he is submitting. So can you argue for him and then for you?
No, I will not argue for him, but
What, you've given him some mantra?
if not.
No, you see, the problem is the submissions you have made so far. That can't be a part of a judgment.
That cannot be. He has
Then
to
what
look
is his
into if there
submission
is
now?
any procedural irregularity in
That's
the
right.
proceeding.
I don't think he is ready with the judgments on disproportionate punishment. But it prima facie appears that it was too harsh a punishment.
That has to come from him. That's what it is. So, तुम्ही हे केली सांगणार तुम्ही हे तो line out.
Yes.
Lordship, my submission is that his past record may not be taken into consideration while passing this argument, and he was not allowed to examine cross-examine his witnesses, Lordship. That is not correct, Lordship. At every stage, he was allowed to cross. He declined.
That's what he says. He was not
Yes.
aware of the
But,
consequences.
If your Lordship would permit, I can place the records. I have taken a stand. I'm
You have the records.
not with me right now, Lordship, but I have taken that plea. And I'll also given some documents here. With the whole records, I can call for Lordship.
No, but the records will be necessary. What else? We have to
Yes,
go by the
Lordship.
records.
Lordship, let the records be perused and let me pass.
How much time will you need?
Lordship, this is from West Bengal, Lordship. At least 3 weeks time, Lordship.
You have understood, Mr. Sharma. You have to prepare your matter. You have to read the charge memo, then the findings of the inquiry officer. Your case could be either number one, that the charge has not been proved. Number two, that there are procedural defects. If he was not allowed to cross-examine, that is a procedural defect. But if he has himself declined, then you can't take advantage of that. We may still see whether his condition, he is a cook, he was a cook only.
Lordship may go on proportionality if at all.
But the proportionality is, I have not seen the case, but 2 minutes, whatever I could see. It is a case of proportionality. It clearly appears
It's
to
only
be.
that, Lordship.
But I don't think are we aware of proportionality? We're not aware. Actually, you take a note, then you make a note. There is, even if a charge is proved, the penalty cannot be disproportionately high. Okay, so you examine whether this is a case where dismissal from service was a disproportionately high penalty. And there are some judgments of this court, Supreme Court. Try to get hold of those judgments, see the ratio, place it. If we find that, all right, the inquiry may not be interfered with, but then the punishment was disproportionately high. We can remand it to the authorities, asking them to impose a fresh penalty short of termination from service, in which event your client may just about survive. But you are not prepared with it today. No? You have to come prepared. You are a High Court counsel. Otherwise, how can if a good judgment is not written, they will go in appeal and set it aside. You will not get anything.
May adjourn the matter today, Lordship.
Adjourn the matter. What will happen on the next day?
Lordship, I will come prepared.
Give him a chance.
Lordship,
You have not given his client a chance. At least give him a chance.
Lordship.
All right. You get the records.
Yes,
You need it in any case. But then how much time, Mr. Petri?
I am very for 3 weeks last.
3 weeks.
Last is. They
3 weeks. 3 weeks. It's a case of dismissal. Prima facie, I think this is a case of setting aside and remanding for a lesser punishment.
Proportionality, Lordship, I will not say now.
I don't have the judgments with me, otherwise I would have dictated the order. He is also unfortunately not prepared. It appears to be a case of disproportionate penalty.
To some extent, yes.
Heard Mr. C. Sharma, counsel appearing for a petitioner. Also heard Mr. R.K. Dev Chaudhary, learned DSGY appearing for the respondents. In this read petition, the petitioner has challenged the order of dismissal from service. The thrust of the argument of the petitioner's counsel, switch off the live streaming. The first plea is concerned, assessment of the same would require examination of the departmental record. Mr. Dev Chaudhary submits that the records are not readily available with him, and if 3 weeks time is granted, he will produce the record. First up. On the point of disproportionality of penalty, Mr. Sharma has also prayed for some time to go through the relevant decisions and place the same before this court. In view of the above, and on the request of learned counsel for both the parties, this matter is directed to be listed again after 3 weeks as a fixed item for hearing. On the next date fixed, the learned department counsel to produce the record. You come prepared, read your case properly, you make a note, you give a list of dates, then only we can pass a judgment quickly. He has not paid his loan, he has not, that's not a ground to set aside an order. These are his personal matters. You understood?
Yes, Let's check.
Yes.
Item 19.
What should I pay for adjournment in this matter?
You pray for
Adjournment.
adjournment. Why?
My senior is
Yes, who is your senior?
Mr. VDP.
Oh, he was there a little while back.
They have to leave.
Huh?
They have to leave.
He had to leave. Somebody said something to him, no? Mr. Nair, would you want to be the cause of more trauma to Mr. Kaur?
No, 14th. The date, my lord, will not.
Mr. Kaur may have many other assignments. All right. A prayer for adjournment has been made on behalf of the petitioner on the ground that the senior counsel engaged in this case, Mr. B.D. Kaur, is unavailable. First up. Mr. U.K. Nair, learned senior counsel appearing for the respond number.
Respond number, my lord, 2, 3, 4, and 5, my lord. 5 and 6. 2 to 6.
2 to 6, and Mr. A. Kalita, learned standing counsel, industries department, appearing for the respond number 1, are present but do not have any objection if the prayer is allowed. Considering the nature of issues involved in this petition, this court is of the opinion that it will be necessary to hear the arguments of senior counsel engaged by the petitioner. As such, on the request of the petitioner's counsel, this matter stands adjourned for 2 weeks. Yes.
Date may be fixed.
Date
As
may
per
be
the
fixed.
convenience.
You can't ask for adjournment and a fixed date.
My senior is
No.
Obliged.
Part 1, part 2, part 2.
Part 2. Item 3.
Lordship, this is an appeal against the order passed by the tribunal, Lordship, at page 29. Wherein the honorable tribunal held that as the fidar cadre of both the persons were same, so their recruitment to the post of secretary, steno grade 1 should be taken as promotion, and accordingly they will be entitled to equalization of pay by following the Finance Department OM dated 10th of September 1997. So in this case, Lordship, I am trying to I would like to impress upon your Lordship by showing that as per going by the rule, Lordship, provisions of rule, so there is no such term like promotion, Lordship, so far as stenographer grade 2 and stenographer grade 1 in sponsor. These are in fact recruitment.
No, the simple question that I'm asking is, when was the other person appointed or promoted or etc. to grade 1? That is Vasavi Bhattacharya.
Yes, she was initially appointed as grade 3 in the year 1983, Lordship. 14/7/1983. And then she got recruited to the post of stenographer grade 2 on 30/9/1985.
39/1985.
85. And
Yes.
then got the post of stenographer grade 1 on 16/9/1999. And so far as respondent in this appeal is concerned, Lordship.
No, just a minute. She got the post of stenographer grade 1 on
16/9/1999.
Yes. And
So-
what about the petitioner? When did she become?
Lordship, initially, so far as respondent in this appeal is concerned, Lordship, she was appointed as grade 3 on 25/6/1983. And
No, but this page 64 says she joined as stenographer grade 3 on 14/7/83.
yes, joining the
14/7 Bashavi.
14/7 other.
Acha, you are talking about the petitioner,
Yes.
the private respondent.
Yes.
I have cleared it.
Acha, give me just let us see.
Left side Bashavi, right side Swapna.
Vasavi is a party here?
No, in
Before the tribunal, she was a part.
tribunal, he was part.
So respondent was appointed as grade 3 prior to Vasavi.
Yes.
Yes, 1 month prior, Lordship. But the respondent, Lordship, but the other person, other lady, Lordship, she got from recruited to stenographer grade 2 in the year 1985. But the respondent in this case, Lordship, in this appeal, she was recruited to stenographer grade 2 1 year later in 86.
All right.
29/11. But so far as grade 1 is concerned, Lordship, the respondent hearing, she got recruited to the post of stenographer grade 1 in the year 1992. But the other person, that is Vasavi Bhattacharya, she got recruited to stenographer grade 1 in the year 1999.
But she is getting more pay than the.
Now, yes, Lordship. Now she is getting more pay than the.
According to you, this is okay.
Yes, Lordship.
How?
Lordship, one table I have annexed here, Lordship, in my appeal, Lordship. Lordship, may kindly see page 64.
Yes. Yes, please.
Lordship, in the first column, it is the respondent here in Lordship. Second column is the Vasavi Bhattacharya.
Yes.
Lordship, may kindly see, he joined as stenographer grade 3 on 29/6/83. Lordship, may kindly see the pay scale 375 to 600. And that was revised, Lordship, revision of pay scale of stenographer grade 2, that was revised And then the revised scale was 657 to 1,100. Lordship may kindly see the last date in the first block, Lordship, on 1/6/1986. In the fitment table, her pay was 750. Lordship may come to the other side, Lordship. Lordship, on 1/7/1985, Lordship, her pay was 725. And in the next block, Lordship, 1/9/1986, her pay scale is at the fitment table of 810, Lordship.
She is still in service. Swapna Datta?
No, Swapna Datta retired.
Retired. Then her retirement benefits have been fixed.
Fixed on the basis of earlier, which she was drawing. And if this benefit is come out, then pension will be improved.
No, Swapna Datta has no grievance against her, Lordship. She only claiming equalization at her rate, Lordship.
So that's what I'm trying to understand. Why she should not get equal pay as someone who is junior to her?
No, that is what, Lordship, I'm trying to solve, Lordship. Lordship may kindly see the date 1/6/1986 in the first block, Lordship. It is the respondent hearing. Her in the fitment table, her position was at 750. Lordship may kindly see 1/9/86 in the next column, Lordship, second block. 1/9/86. The pay scale of Vasavi Bhattacharya was 810.
Yes.
Lordship, the respondent hearing, she got recruited to the post of stenographer grade 2 on 29/11/1986.
I was also 800.
1986, so 810.
810, Lordship.
Yes, she was also getting 810.
Yeah. Subsequently, Lordship, as she already got promotion to the grade.
No, so the matter of what, 1.5 months?
Yes, Lordship.
29/11/86, and here it is 1986.
Lordship.
Then what happened? They're all same.
No, I am not claiming on grade 2. I am claiming from grade 1 onwards.
So grade 1, when did the private respondent get promoted to grade 1?
Grade 1, I have given 16/9/99.
And the other lady?
She is 99, Lord.
I got in 2/4/1992. My lord, may I point out why this discrepancy, my lord?
1 minute, 2/4/1992.
92.
Yes.
Discrepancy was that, my lord. There was an interview for grade 1. I passed in after my qualifying service. I passed. He failed. So he did not pass for 10 years. So when he was in grade 2 for 10 years, he got.
He means who?
Sorry, not he. She. That is the.
Don't change their gender now.
Sorry, my lord. Vasavi.
You are changing pay scale. Somebody is changing gender.
Sorry. Vasavi Bhattacharya. I am naming Vasavi Bhattacharya got 2 increment as career advancement scheme. That is why in the year 1999 he got in grade 2 increment she got again here. She got 2 increment. Then she again promoted to grade 1 thereafter. So when she was promoted to grade 1, again she got another 2 increments. So she, like this way, she jumped to me. Because when she was in grade 2, last basic and my basic at that point of time as a grade 1 was the same, equal. Kindly see, I have given.
These are 2 technical matters, Mr.
And this OM is covered. On the basis of the OM, the judgment was passed. It was covered by the
OM dated 10 September 1997.
Yes.
So which paragraph of the OM?
Paragraph of the OM I am referring. Page 55. Office memorandum so and so.
Equalization of second paragraph, equalization of pay of senior government employee or stepping up of pay of senior government employee with junior is admissible on the following cases only. It is therefore impressed upon the administrative department to examine the proposal carefully and refer so. Number one, both the senior and junior government employee whose equalization oblique stepping up of pay is proposed should be recruited to the same cadre post initially and should be promoted from the same source. This is covered.
So your client was promoted to grade 1
Grade 1.
and she was also promoted.
Promoted.
But in grade 2, she got 2 more increments than your client.
Because I promoted earlier. I was, in the meantime, I was grade 1. So, one judgment, may I show Supreme Court judgment, 2022 6 SCC 183. Because with the same language, same office memorandum, but it is with respect to central government. No, FR 22 related. Upper division clerk. Inspector reduced selected.
What is the judgment?
Well, the 2022 6 SCC 183. Well, kindly see paragraph 3, the facts of the this cited case. The respondent herein original writ petitioners were appointed as LDC on 1-73 and 3-8-73 respectively. Thereafter, they were promoted to the post of UDC clerk on 4-10-8-76. That one of the respondent was promoted to officiate as an inspector with effect from 2-4-1981. And the other respondent was promoted to the officials as an inspector on 13-7-1981. Once the CK Satish was appointed as an inspector on 17-12-81 by way of direct recruitment. And one Sri so-and-so was appointed as inspector by way of direct recruitment on 15/5/82. So kindly see now paragraph 10. There was an alumni with the direct equity and promoting. The High Court has paragraph 10. The High Court has therefore rightly relied and or consider FR 22. In our case also FR 22 is applicable. And the order issued by the Government of India on removal of anomaly by stepping up of pay which read as
All right, we'll
under.
continue at 2. This take a little time. But today we'll finish it off, whichever we do. Mr. Nayak, the point is, as we understand, is on one area. You see, these are all promotional posts. That is what the tribunal has held. And we see no reason to disagree with that. If these are promotional posts, then FR 22 would have a bearing in this case because it will be a question
If
of.
it is promotion, Lordship, then I have no case, Lordship.
Why do you say it is not promotion?
It's because of the rule, Lordship. That is what I'm trying to say. Lordship will notice. First, she was recruited to stenographer grade 2 in the year 1985. Then she got recruited to the stenographer grade 1 in the year 1999. Why this longer period, Lordship?
So you address. Yes, Mr. Nayak, why do you say it is not an order of promotion?
Yes, Lordship, may kindly come to the rule, Lordship. Rule is at page 34, Lordship.
Page 34, yes. Yes.
At page 36, your Lordship will get the class and cadre, Lordship. Serial number 3. Below. The service cell consists of the following cadres: special officer, an ex officer deputy secretary, then Lordship at 2 senior grade stenographer, and ex officio under secretary, 3 Lordship stenographer grade 1, 4 stenographer grade 2, 5 stenographer grade 3. Then Lordship may come to page 38. Serial number 5, Lordship, method of recruitment. Recruitment to the various cadres in the service shall be made in the manner prescribed hereinafter, namely 1. Special officer and ex officio deputy secretary. Lordship may kindly see the next column, by promotion from senior grade stenographer and ex officio undergrade. Lordship will mention record that word promotion. At 2, Lordship, senior grade stenographer by promotion from stenographer grade 1. At serial number 3, Lordship, stenographer grade 1 by recruitment. Lordship, in case of earlier officers, Lordship, it was promotion. Now it is recruitment. Stenographer grade 1 by recruitment in accordance with Rule 6 and Schedule 1, Part B. Stenographer grade 2, Lordship, same by recruitment in accordance with Rule 6 and Schedule 1, Part B. Lordship may kindly see Rule 6, Lordship. Same page, Lordship.
Yes.
Appointment to the cadre of stenographer grade 3 shall be made by direct recruitment. We are not concerned, Lordship. And the cadre of stenographer grade 2 and stenographer grade 1 shall be filled up by recruitment in accordance with the procedure as provided in this rule. For appointment to the stenographer grade 1 from stenographer grade 2, one should complete 6 years of continuous service in either or in both the cadre of stenographer grade 2 and grade 3. The appointing authority shall make the appointments on the basis of recommendations by the commission in accordance with the procedure hereinafter provided. So for recruitment to the post of stenographer grade 1, commission will recommend a list.
Which commission?
Assam Public Service Commission.
So the promotion of or recruitment of these private respondent was as per recommendation made by the APSC.
Yes, to grade 1.
Is that correct?
Yes, lordship. A department, they will have to go through a particular test, lordship.
Advertisement was issued.
Yes, lordship.
Huh?
That is the clerk, my lord. Because kindly say in the.
No, let him
Yes,
finish. Let him.
yes.
Lordship, that is the reason, lordship, in spite of that Vasavi Bhattacharya getting recruited to the stenographer grade 2 in the year 1986, 85, she got recruited to the stenographer grade 1 in the year 1999. Because for all these long years, she was unable to get qualified the skill test, lordship. It was conducted by the APSC. But the respondent here in lordship, she qualified that examination earlier. Accordingly, she got recruited to the post of grade 1. Lordship may also see the part 1, rule 6, schedule 1, part B, lordship.
Part 1.
Schedule 1, part B. Schedule 1, part B is at page 50. Page 50, lordship, 50. Schedule 1, part B, rule 8. Qualification for recruitment. The minimum qualification and experience for recruitment to the cadres of the service shall be as prescribed below. Stenographer grade 1, pass the degree examination or an equivalent examination from a recognized university. 2, candidates should complete 6 years of continuous service, either in the cadre of stenographer grade 2 or stenographer grade 3, or in both on the 1st January of the year of examination. 3, pass the speed test of 150 words per minute in English stenography or 120 words per minute in an Indian language stenography.
No, Mr. Nayak, see, the question is simple. Let us, this promotion and recruitment, the rule is faulty. Let's be very clear. What the drafting man who has drafted, we don't know. This must have been done many years back. This is the word recruitment, what he understood by recruitment, God knows. Because it appears that the idea is of promotion, but the word has been used as recruitment.
No, lordship. Lordship, contrary, lordship.
Let us take it that it is direct recruitment. Then also, how can you give a lower pay scale to someone who has been recruited earlier?
No, lordship, for that, lordship, I will again go back to the page 65, lordship. Page 65, lordship. In the
Page 65.
Yes.
Yes.
Lordship, grade column 1, that is grade 1, lordship mentioned. In the column 2, lordship will say grade 2. That is Vasavi Bhattacharya was still in the cadre of grade 2, but the respondent herein was already in grade 1. Lordship, I am pointing out the date 1/4/1999. Scale was 6850. Lordship may see the corresponding on the other side, lordship, 1999, 6850. She is grade 2, but getting the same scale.
All right.
Then lordship may come to 1/4/2000. 1/4/2000. So far as respondent is concerned, lordship, it is 7100. In the other side, lordship, one line is missing there. That is one, prior one is 1999. Next one should be 19/2000. So on 19/2000, lordship, both of them were getting the same scale, lordship, 7100. Next line, your lordship will read, recruited as stenographer grade 1, joined on 16/9/1999. Rupees, that is the scale, lordship. And lordship will see the scale now, 19/2000. Next, second column, lordship, 7600.
Correct. So on 16/9/2099, that was the scale of stenographer grade 1.
Yes.
Correct.
Yes.
So she was also a stenographer grade 1.
No, lordship will see her scale, lordship, 1/4/2000. The respondent, lordship, 1/4/2000. The respondent herein was at 7100.
That is precisely what she is complaining about.
No, lordship. Lordship, I am at grade 2, lordship. I am already at a level, lordship. This is called fitment table, lordship.
So somebody who has joined earlier will get lower pay scale. That is the idea.
No,
Somebody who comes in later gets a higher pay
no,
scale.
Lordship, for that Lordship, I have to go to the submissions made in the affidavit also. But Lordship, here they were already doing equal scale Lordship.
Right.
But the moment she got promoted to the higher cadre Lordship, she got one step ahead of the respondent hearing Lordship. That is why I'm pointing out to 2000 Lordship. Lordship, in that table, Lordship, fitment table 15. Table 15 Lordship, that is the scale we are talking about, 3760 up to 9400. Lordship will see a serial number, then basic pay in the pre-revised. Next one is revised Lordship. It was in the year 2010 report Lordship. It was made implemented from 1/6/2006 Lordship. An earlier one prior to that from 1996 to 2006 Lordship. Lordship will see the next about the Vasavi Bhattacharya Lordship. I'm mentioning the scale of 6850. Next page, Lordship will see second column 6850. Page 65. Second line from above, Lordship.
Yes.
6850. She was drawing 6850. Here, Lordship, on 1/9/2000 Lordship, she was upgraded to 7100. Next one. Then Lordship will come to fitment table 22. As page will be different Lordship in that table. It's continuously going Lordship. Fitment table 22. Fitment table 22. Lordship will see at serial number 8. It is 7100.
This is a terrible complicated matter, Mr.
No, if I read the submission Lordship in the affidavit, it will become clear Lordship. Document take me to my affidavit Lordship. So what I was trying to show from the rule Lordship, to get recruited to the post of stenographer grade 1 Lordship, I don't need to have any works experience in the grade 2 itself Lordship. Even a person holding a grade 3 post can get recruited to the post of grade 1 if I have 6 years experience in grade 3 Lordship. Only criteria is I have to pass the skill test. Even a person.
And you must have continuous 6 years service.
Yes. 6 years service either in grade 3 or in grade 2 or both. So to get recruited to the post of grade 1, I don't need to work at grade 2. If I don't need to work at grade 2 Lordship, grade 2 cannot be a feeder cadre of grade 1. That is where Lordship, in my humble submission, learned tribunal made the error Lordship. If I am not required to work at grade 2, from grade 3 itself, I can become eligible to get recruited to grade 1. How can I get to become a feeder cadre of grade 1? Lordship, may kindly take my affidavit, Lordship, at
Yes.
page 24, Lordship. It is an affidavit before the tribunal, Lordship. I'm coming to the next page, Lordship. Serial number 5, Lordship. That as regard the statements made in paragraph 6-7 of the memo of appeal, the deponent denies the correctness of the same and states that the appellant Sri Dr. is respondent here, Lordship, and the respondent Sri Bhattacharya were appointed in the cadre of stenographer grade 1 and not promoted as claimed by Srimati Dr. Promotion from lower cadre to the next higher cadre is made on the basis of seniority in the gradation list of that particular lower cadre. But in case of steno, As per procedure laid down in Rule 5 of the Assam Stenographer Service Rules 1995, Annexure 1, appointment to the cadre of stenographer grade 2 is made from stenographer grade 3 on the basis of select list prepared by the board, and to the cadre of stenographer grade 1 from the select list recommended by the Assam Public Service Commission after having speed test in stenography. So the respondent number 4, Srimati Bhattacharjee, was appointed as stenographer grade 2 prior to the appellant on 3985, though she was junior to Srimati Datta in the cadre of stenographer grade 3, and Srimati Datta, though junior in the cadre of grade 2, was appointed as stenographer grade 1 prior to Srimati Bhattacharjee. As such, there may be disparity of pay. There is no disparity with regard to the fixation of pay of Srimati Datta. The appellant as stenographer grade 1, her pay on the date of her joining as stenographer grade 1, as well as the respondent number 4, Srimati Basavi Bhattacharjee, was fixed straightway as per FR 22-1A1 as ordered for Annexure 2. 6. That as regard to the statements made in paragraph so and so on, the matter was considered in consultation with Finance Establishment A Department and later found inadmissible on examination as per Finance Department OM number so and so dated 10/9/97, Annexure 2. So her prayer was regretted on the ground that the post of stenographer grade 2 and stenographer grade 1 are not promotional posts. Equalization of pay is not a matter of right. Government may consider or may not, which depends upon the circumstances of the two case and varies from case to case. 7. That as regard to the statement made in the deponent denies the correctness of the one as per point 1 of Finance Establishment Department OM number so and so that 10/9/97, equalization or stepping up of pay is admissible if both the senior and junior government employee are promoted from the same source. But Srimati Datta, the appellant, was not promoted to the post of the stenographer grade 1. Instead, she was appointed as stenographer grade 1. If it was promotion, the respondent number 4, Basavi Bhattacharjee, would have got promotion to the higher post of stenographer grade 1 prior to Srimati Datta, the appellant, as she was junior to Srimati Bhattacharjee in the cadre of stenographer grade 2. There is no disparity in fixation of pay under for 22(1)(a).
So
right?
Bhattacharjee was senior to Mr. Ghosh's client in the grade 2.
At grade 2, she was senior to her client lords, his client lordship. But she got promotion, I mean recruitment to the cadre stenographer grade 1. It was almost 13-14 years later, she got recruited to the cadre of grade 2. It was only because she was unable to qualify the skill test lordship conducted by the APSC.
So it is a selection post.
Lordship, it was only on the basis of recommendation by the APSC, one can get recruited to the post of stenographer grade 1. So that is our basic case, lordship. So this OM dated 10/7/1997 is applicable only in case of promotion, lordship. And lordship, in my humble submission, lordship, lordship may also take note of paragraph 8, lordship, from the middle portion, lordship. In case of the appellant, Srimati Datta, as well as the respondent for Srimati Bhattacharjee, pay was fixed under FR 22(1)(i) on the basis of last basis drawn on the lower post. Disparity occurs in other cases also, other cadres also. There are lots of senior undersecretaries, superintendents, senior administrative assistant in secretariat drawing pay at a lower stage than their juniors due to one or some other reason. In case of stenographers in secretariat, once Dijen Sharma, stenographer grade 2, is drawing pay at a higher stage of rupees 8750 PM with effect from 1/4/2008, then Srimati Datta, who is drawing pay at the same stage of rupees 8750 PM with effect from 1/6/2008. So this happens, Lordship, and in my humble submission, Lordship, to cope up with situations like present situation, Lordship, the rule was framed in that manner, Lordship. So that is my submission, Lordship. Lordship, if I could summarize, Lordship, and one more thing, Lordship, I would like to submit, Lordship. So far as that notification is concerned, Lordship, 1977. Lordship will see at serial number Roman 6. Page 56, Lordship. Roman 6, Lordship, small Romans. Claim of equalization will not be considered after 1 year of promotion in case of those for whom no payslip for AG is necessary, and 1 year from date of receipt of the payslip where AG's payslip is necessary for the. In any case, Lordship, if any claim for equalization or stepping it will be consideration within a period of 1 year only, Lordship. But in the present case, Lordship, her first representation was in the year 2006, Lordship. But that is my submission, Lordship. First, it was claim was made in a much later than is required under the notification, Lordship. It was made only in the year 2006 only. Then, Lordship, tribunal made an error in holding that stenographer grade 2 is a feeder cadre of grade 1. And going by the rule, even a grade 3 can recruited to grade 1, Lordship. So grade 2 is not a feeder cadre of grade 1. That is my second submission, Lordship. And if it is not a promotional post, Lordship, if it is a recruited, Lordship, then no question of applicability of notification of 1977, Lordship. One more argument, Lordship. Lordship, there is no ambiguity in the rule, Lordship. Rule is quite clear, Lordship. Lordship, if it is not, if no ambiguity is there, Lordship, it should be read as it is, Lordship. No interpretation is necessary, I think, in my humble submission, Lordship. Lordship.
Yes.
My lord, kindly see page 34. The rule was 15 February 1996. And I was promoted on 2/4/1992. Lordship got it? The rule was subsequent in 1992. Now, their contention is that it is a recruitment post. If it is a recruitment post, then the salary of Bashabi would have been fixed at the scale where it started as a grade 1. Why the benefit of all this has been given to Bashabi? If it is a promotion recruitment post, then he may get additional increment, etc.
All right, what we'll do is we'll implement the accountant general and get his opinion on this matter. Because it's very difficult.
And the judgment, my lord, which I have shown, my lord, in that judgment also, though it was of the Union of India, but office memorandum is ditto, my lord. In that judgment, kindly see.
No, Mr. Ghosh will have the AG present in this. Let us get his opinion. The Principal Accountant General, A&E Assam. Let us get some assistance from a third view also. Your arguments maybe, both these arguments are equally good and attractive. It can go this way, it can go that way. It's not possible for this court to choose either side.
And in the recruitment.
What was the rule when your client was recruited in grade 1 stenographer?
Yes. Now, the rule was same at that point of time, but language in the rule, this rule also kindly see at page, recruitment rule kindly see, my lord. At page 41, there shall be no age relaxation, age restriction for promotion within the service. That means.
No, the tribunal says these orders have trappings of order of promotion. But the fact of the matter is that we find he is correct. He is saying the rules are very clear. It has to be recruitment. The person has to pass the skill test.
Yes.
Otherwise, he will not be so promoted.
For the purpose of skill test also, my lord, in the pay commission, additional increment was given those who passed this type of qualification.
That's correct. But the person who does not pass skill test will not be promoted even if he is or she is a senior.
No, he will not be promoted.
Then it's a selection post.
It is a selection.
Then
now, if it is a selection post.
Selection post is not a promotional post.
Not a promotional post.
So on that count, I can straight away set aside the judgment, but I don't want to do that. I want to get a little more clarity on what is this.
But in my appointment, initial appointment as a grade 1, at that point of time, this rule was not there. The appointment letters language is there, my lord. Srimati Swapna Dev Chaudhary, stenographer, grade 2, having passed the speed test of 1 so-and-so in English stenography held in Assam Public Service Commission on 9 March 1992, having completed 6 years of service in the lower grade, is appointed temporarily as stenographer grade 1 in so-and-so, so-and-so. And the basic pay which was fixed at grade 1 post, 2270.
Who is the standing counsel for the controller and the?
No, he is not the counsel.
Accountant.
I heard Mr. P. Nayak, learned counsel appearing for the petitioner. Also heard Mr. S.K. Ghosh, learned counsel appearing for the respondent. In this petition, the judgment and order dated 4/5/2010 passed by the learned administrative tribunal in appeal number ATA/2009 is under challenge. First of, the basic controversy pertains to the claim of the respondent regarding pay parity First up, the learned tribunal has allowed the petition filed by the respondent by relying upon a notification dated relying upon the notification dated 10/9/1997 issued by the government of issued by the Commissioner and Secretary to the Government of Assam, Finance bracket ESTT.A bracket close department, by holding that the recruitment of the respondent from stenographer grade 2 to stenographer grade 1 was for all practical purposes by way of promotion. First up, the aforesaid plea of the respondent has, however, been strongly refuted by the petitioner's counsel by submitting that the recruitment rules of 2006 itself is clear that the post of stenographer grade 1 is to be filled up by way of recruitment based on the performance of the candidate in the skill test, and therefore the learned tribunal was clearly erroneous in recording such a finding. Full stop. According to the petitioner, the respondent is not entitled to parity of pay with the other departmental candidate, even though she was junior to her in the grade 1, in the cadre of grade 1 stenographer. Mr. Ghosh has denied such assertion, full stop. Since the issues raised in the matter relates to intricate issues of pay fixation, stroke pay parity with reference to the fitment table, this court is of the opinion that what is this principal accountant general?
Yes, sir.
A&E bracket close Assam
No, sir. No, sir.
should be heard before a final decision is taken in the matter. As such, the principal accountant general A&E Assam is hereby included as respondent number 2 in the connected writ petition, full stop, registry to make necessary endorsement in the cause title. A copy of this writ petition be served upon Mr. S.K. Medhi, Learned Standing Counsel, AG, bracket A&E Assam, bracket close. Let this matter be listed again after 4 weeks in the part 1 list by reflecting the name of Mr. S.K. Ghosh and Mr. S.K. Medhi as the learned counsel for the respondents. Let us see what they have to say. We need a little more clarity. Otherwise, difficult. Mr. Ghosh?
My lord, with regard to Basobi, there was no wrong fixation has been done. That was not my case. My case was that.
No, Basobi was right.
Basobi was right.
Your was wrong. But you want to demonstrate your plea
That
by referring to Basobi.
At part with Basobi.
Correct.
At part with
But
Basobi.
then what is arguing? This is on a very technically, you see, it is difficult to accept that it was a promotion. Very difficult. The easiest way, if I dictate the judgment today, I will allow the writ petition. So, but before coming to a conclusion, I thought it is better to have a little more expert opinion. This is not a case of promotion, although it looked like, because the rules are different.
If it is not a promotion, then in that case, this fixation which has been done in case of Basobi, that was wrong.
That is what we want to know from the accountant general.
So
That is what I would like to know.
because in one case they are saying in Basobi was promoted, I am recruited.
That is what we want to know, because let their opinion be on record, then we'll conclude it. You have to wait for some more time.
Yes, yes.
It's only pecuniary benefit.
Lordship has heard this matter in length, Lordship will keep this part or not.
Sorry,
Lordship will keep this matter as part or not.
list this matter again after 4 weeks, showing it as a fixed parted item. All right. Any other matter? Anybody ready? Part 2 hearing, Mr. Fukal?
The next item, actually, we have the respondents, we have a mobile party, petitioners are, because they're not here.
Petitioner is not there. Nobody is there for hearing. Everybody wants interim order and then go home by 12:30. All right, if nobody is there, then I have to rise. There's no point dismissing these matters.
My lordship, I'm for the item number 10, your lordship. Senior advocate Mr. MP Chaudhary is leading this case, your lordship. And due to some personal difficulties, he have to leave, your lordship.